People. Yes. How are you guys? Hi, everyone. Hi, everyone. How are you? I hope you all are doing super amazing, guys. Yes, people. Yes. Yes, people. People, I would want you to share this link to as many people as possible, to as many groups, wherever you are in. Now, we are going to have super amazing fun. We're going to have a lot of conversation that will only be possible when people would be there. Right, people? I'm also sharing this link to as many groups as possible. Hi, Venkatesh Sharma, Atul PS. Venkatesh Sharma, how are you? Tejasvi Pawar. Hi, guys, how are you? Guys, I would want you to share this link to as many groups as possible because the more students are over there, the more lively the class will be, right? Rahul Kanchan. Hi, Rahul, how are you? Is my voice audible, guys? Is my voice audible? Just give me a quick thumbs up if my voice is audible. Amazing, Tejasvi. Great. Venkatesh Sharma. Where are you from, Venkatesh Sharma? Atul PS. Rahul Kanchan. How are you guys? Venkatesh Sharma, are you from Chennai? Venkatesh Sharma, are you from Chennai, Venkatesh Sharma? Vijay. Hi, Vijay. Hi, Gauri. How are you guys? That's super amazing. More people have come in today. Chandra Shekaran Gopal sir. Hi, sir. How are you? Good evening, sir. Good evening. Bellary, Karnataka. Oh my God, that's super cool. So sweet. Guys, share this marathon link to as many groups as possible, guys. Happy evening, Vijay. I'm great, Atul. I'm great. Super great. Guys, are you guys sleeping well? Because we are having marathon for continuous 4 hours. Are you guys sleeping well? I'm doing super great, Venkatesh. Vijay, oh my God. So sweet of you, bro. So sweet. Vijay, is this your first class or were you watching the last two marathon lectures? I'm also super excited, Vijay. Today is going to be super fun, guys. Today we're going to complete the three most lengthiest chapters of Companies Act 2013. I hope you all got the notes, guys. Today we're going to complete the three lengthiest chapters of Companies Act 2013. Amazing, Vijay. Amazing. So sweet of you. Guys, everyone, I would want you to tell me one thing, which is that chapter that you hate the most apart from insurance, apart from banking. Which is that chapter that you hate the most? Gauri, Chandrasekhan Gopal sir, Venkatesh Sharma, Atul PS. Vijay, you hate the famous chapter the most. Okay. After yesterday's lecture, is that hatred reduced to some extent, Vijay? Pooja Gupta. Hi, Pooja. How are you? Where are you from, Pooja Gupta? You're from Mumbai. Oh, great, great, great. Corporate governance, Venkatesh Sharma. Okay, I have noted this. Corporate governance, insurance, banking. Abhinetra, good evening, Abhinetra. How are you? Not now. That's sweet, Vijay. That's sweet. Pooja Gupta, which is that chapter that you hate the most in corporate and economic laws? Which is that chapter that you hate the most in corporate economic laws? Guys, I would want you to drop me all the doubts that you have, all the doubts, even not only during the marathon, even after the marathon when you watch these videos offline. Just note down the doubts and just drop all your doubts in the comment section. Okay, within 24 hours I will make sure all your doubts are resolved. Okay, today we're going to have super amazing fun, guys. Super amazing fun. Okay, so guys, just drop the chapter that you hate the most in the comment section. And till then, I will start with the new chapter. That is. So yesterday material not received. Chandrasekhar Gopal, I will do one thing. Just tell the team. Yes, Chandrasekhar Gopal sir, you will receive the notes shortly. Guys, are you guys ready? Ready, 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 ready? Just give me a quick thumbs up if you guys are ready. Give me a quick thumbs up, guys. Guys, if you want to have dinner, just let me know. I will give you a 15 minutes break, okay? Since last 2 days, you guys were just listening to me all the 4 hours. You were just skipping the dinner. I don't want you guys to skip the dinner, okay? K. Nandini, sir, please teach how to write case study questions. Nandini, the first thing that we are going to do today is how to solve case study questions we are going to understand. Anuradha, hi Anuradha, how are you? Where are you from? Chalo, shall we get started? Just drop me a quick thumbs up and let's get started. Today our agenda is, people, today we are going to complete three of the most lengthiest chapters in Companies Act 2013. Once we are done with these three chapters, the remaining chapters will be a cakewalk for you. Hi sir from Chennai, Anuradha. Okay ma'am. எப்படி இருக்கீங்க? All right. So let's get started, guys. Let's get started. K. Nandini, when we will studying, what we'll do is we'll start with this chapter. Okay, as you have told that you want to know how to solve case study questions. So first thing we're going to do is we're going to start with this chapter. In this chapter, we're going to understand how to solve the case study questions in the most beautiful way possible. All right, perfect, perfect, perfect. All right, let's get started, guys. Just drop me a quick thumbs up. Just drop me a heart. Just drop me a quick thumbs up and share this link to as many people as possible wherever in groups you are in for corporate economic laws. Just drop all these link so that everybody will get benefit from this marathon lecture. All right, all right, all right, all right. Let's begin, people. Let's begin. Board of Directors and KMP. The first chapter that we're going to begin is Board of Directors and KMP. Perfect, perfect, perfect. Siddesh ready? Okay, Siddesh ready? Guys, Siddesh ready? You all know him now. He is my bestest friend. So he has come here to give me a sweet support. Hi, Siddesh ready? All right, sir. All right, guys. Let's begin. Board of Directors and KMP. Board of Directors and KMP. Perfect. People, what I have done is, since last two marathon lectures, the format that we were following was, first we were completing the important topics, then we were looking at the expected questions, then we were solving the MCQs, correct? But in this chapter, what we are going to do is, important topics will be explained to you. Below the important topics, I have also given you how the question will be asked in the exam. Okay, how case study questions will be asked in the exam and how are you going to solve these case study questions, we're going to understand. Okay, so that after important topics, again, we don't have to come to the expected questions. We're going to understand the important topics along with the expected questions, so that you should also know that simply reading or learning a topic would not be sufficient, people. You need to know how the questions is going to be asked in exam, and you have to be prepared for that twisted and turn type of questions. Okay, everybody, just drop me a quick thumbs up if you guys are with me, and let's get started. The first section is, people, 149. 149 is the section. Number of directors. Section 149 of Companies Act 2013. Now, people, let's first understand how the question will be asked in the exam. Okay, XYZ, a public company, has recently witnessed significant growth with paid up capital increasing to 120 crore and turnover crossing 350 crore. The company board comprises only 5 directors. The company has been asked to appoint a woman director due to the recent provisions of the Company's Appointment and Qualification of Directors Rules 2014. Discuss the criteria for the mandatory appointment of woman director in XYZ Limited. Explain the provisions regarding the maximum number of directors and any potential adjustments that might have to make. This question is going to simply come for 7 marks, people. 7 marks question will be coming like this. Okay, you don't have to be scared. First thing first, never ever get scared. First ask yourself, what exactly is this question is trying to ask me. Then when you get the underlying answer, and then you have to start drafting your answer. Understood? Now let's understand how to solve case study questions. How to solve case study questions. People, tell me one thing. How would you solve this question? Tell me in 5 to 6 words, how would you solve this question? What will be your approach? Tell me quickly. What is going to be your approach? How are you going to solve this question? Okay, let's forget about the provision. Let's forget about the answer. Just tell me the structure of your answer. Just tell me the structure of the answer. How are you going to solve this question? Give me the structure of the answer. Don't You don't have to give me any answer. Just give me the structure of the answer. What would be your approach? Nandini, Pooja Gupta, Anuradha, Chandrasekhar Gopal sir, Vijay, Pooja Gupta. I would want you guys to tell me how would you structure this answer if this question is asked for 7 marks. Yes, people, quick, quick, quick. Give me quick answers. We need to complete this marathon by 9 p.m. is my target so that you guys can have lunch and you can also try to revise whatever I have taught you. Just answer me in 5 words. How are you going to attempt this answer? Brief about minutes, minimum and maximum number of directors, then criteria about women director, then conclusion. First applicable, perfect Venkatesh, perfect. First applicable provision, second given case, third conclusion. Okay, good enough. Rahul Kanchan, you are super amazing, Rahul, but we need to understand that we are writing law exams, okay? So we need to act like lawyers when we are writing law exams. So always remember, first thing first, provision, case, conclusion. Perfect, perfect, Pooja, perfect. First thing first, we're going to write provision. No, guys. First, we're going to write the facts of the case. First, we're going to write facts of the case. What exactly is the situation? What exactly happened? First, we're going to write the facts of the case. We're going to write in points A, B, C, D, E. Okay? Facts of the case. Are you guys with me? Just give me a quick thumbs up. Then what we are going to do is we're going to write the legal question involved. Legal question involved. Legal question involved. In this case, legal question involved is what is the criteria for mandatory appointment of a woman director? Is the legal question involved? Number one. And is there any potential adjustments that might have to be made? Is the second legal question involved. So we need to write the legal question involved. Exactly what is the question trying to ask? A and B. Are you guys with me? Yes. Now that you have written the facts of the case, you have written the legal question involved. Now you have to write the provisions involved. What does Companies Act says? Legal question involved, facts of the case, provisions involved. Okay, you have to tell provisions. Over here, you have to start with as per the Companies Act 2013. If you remember the section, well and good. If you do not remember the section, that's completely okay. Just write as per the Companies Act 2013, A, B, C. Now that you have written the provisions, you have to write analysis. Analysis or conclusion. Over here, you have to give your exact answer. Normally, what people do is they will just simply write the provision involved and analysis. That's it. Nothing else. So what happens is normally when the examiner checks your answer for 7 marks question, your answer seems to be very, very short. Even though your answer is complete, your answer seems to be very, very short. So what you have to write, you have to educate the examiner. People always remember, always write answer in such a way that you educate the examiner. You teach the examiner basically. Okay, educate the examiner should be the main objective. Examiner should feel that yes, this guy knows the answer. That is the reason why he is writing the facts of the case. That is the reason why he is writing legal question involved. That is the reason why he is writing provisions. And that is the reason why he is writing conclusion. Okay, this should be your answer. Nandini, are you clear? Nandini, Pooja Gupta, Venkatesh Sharma, Rahul Kanchan, Vijay, give me a quick thumbs up if you guys are with me. Just drop me a quick, sweet, lovely thumbs up if you guys are with me, guys. This is how you have to answer every single case study questions, okay? No matter how easy it is, no matter how difficult it is. If you write in this way, your impression in the minds of the examiner will be super amazing, guys. Impression matters a lot, people. Impression matters a lot. No matter how much knowledge you have, if you're not able to command that impression in the mind of the examiner, that's it. Your answer should look like the answer of an all India rank paper. Okay, your answer should look like a all India rank paper. Understood, people? Even though it doesn't matter you know the answer or not, but make sure your impression is very good in the mind of the examiner. In the end, impression is everything. Okay, always write an answer in such a way that examiner should feel that yes, this guy or this girl really knows the stuff. That is the reason why he or she is writing so beautifully. You have to command that respect. Okay, simply learning the provision and writing the provision, anybody can do that. Okay, you need to understand that there are thousands of students who are giving their CMA final exams. Everybody have got the same study material. Then what makes you different from them? Now, not everybody can pass the exam, right? So there should be something unique, something different in your paper. And this is how you have to write your answer. Are you guys with me? Perfect. Rahul, Tejasvi Pawar, Gaudi, Pooja Gupta. Amazing. Guys, just take a quick screenshot. This is how you have to write the answer. Just take a quick screenshot. After marathon lecture also, I'm going to shoot a video specifically for you as to how to remember the sections in a magician's way and how to write answers, case study answers, so that you end up commanding respect and impression in the mind of the examiner. Okay? Yes. If you guys need anything else apart from this marathon, just kindly let me know. Within 24 hours, I'll be back with all the explanation that you need. Okay? Thank you, Vijay. Thank you so much, Vijay. Thank you so much. Okay? If you guys are giving me 4 hours of time every day, that really means the world to me. So I can do anything for you guys. Just let me know whatever you need. I'm going to give you. If you need MCQ questions, more MCQ questions apart from the 50 MCQ questions per chapter, I will give you. If you still did not understand how to write case study answers, let me know. I will explain you again. Okay, after this marathon lecture ends, the ones who did not understand the case study, how to write the case study questions, just let me know. I will solve it for you. Okay? All right. So let's get started, people. Let's get started. Okay? Just drop me a quick thumbs up if you guys are with me. Yes. Perfect. Okay. So people, quickly will revise everything. Okay? Please share the notes, sir. Tejasvi Baba, you did not receive the notes? Okay. I will tell my team to share you the notes. Okay? Yes. They will share it with you. Okay? All right. People, number of directors, section 149 of the company is at 2030. So, what is the minimum number of directors required in a company? If it is a public, people tell me, is my notes visible to you? Is my screen visible to you? Or do I need to zoom it like this? Please provide notes for case study questions, sir. Sure, Nandini, sure. Notes are over here only. Nandini, see, case study questions are over here only. Okay. If you need some other separate notes, if you want a more clarified case study questions, answers, I will give it to you. Okay. Just wait till the marathon gets completed. Then whatever you guys need, I will give it to you. Okay. Perfect. All right. So let's get started. Number of directors, section 149. If it is a public limited company, minimum number of directors is 3. If it's a private limited company, minimum number of directors is 2. If it's a one-person company, minimum number of directors is 1. Okay, perfect. Maximum number of directors is 15 allowed. If you want to appoint more than 15 directors, you will need a special resolution. Okay, woman director, if the paid up share capital is more than or equal to 100 CR or the turnover is more than or equal to 300 CR, you need to appoint a woman director where? In listed companies. If a woman director position falls vacant, that position should be filled within how many months, guys? How many months? Within 3 months, the position of the woman director should be filled if there is a vacancy. Now, resident director, what it says is every company should have one resident director. What is the meaning of resident director? Resident director means a director who has stayed in India for at least 182 days in the last preceding financial year is called as resident director. Now, what do you mean by independent director? Let's understand. People, this is going to be super amazing. Okay, everybody with me? Everybody with me? Quick, just give me a quick thumbs up. We will understand this provision with the logic. Listed companies must have at least how many directors as independent? 1/3 of directors as independent, correct? 1/3 of directors as independent director. Listed company should have. Yes, yes, yes. Now, people, I will tell you one thing. If the chairman is a non-executive director, we need 1/3 of directors as independent director. If the chairman is a executive director, then half, 50% of directors should be independent directors. Can you tell me why is this provision made? 1/3. If chairperson is non-executive, we need 1/3 of directors as independent. If the chairperson is executive director, we need 50% of directors as independent director. Can you tell me why this provision is made, or are you guys just simply learning the provision? Can you guys tell me what could be the possible reason for this provision? People, in beginning I will go slow, gradually I will pace up. Okay, just tell me what could be the possible reason for this provision. If the chairperson is the executive director, 50% of directors should be independent director. If the chairperson is a non-executive director, 1/3 should be independent directors. If you guys know the answer, just tell me the answer. If you guys do not know the answer, just drop me a thumbs up that you do not know the answer. Yes, yes, yes. So I have got my mobile so that I can know. For better governance, Venkatesh Sharma, perfect, perfect, perfect. Guys, I will tell you one thing. There are two types of directors. Okay, right now there are two types of director. We'll understand: executive director and non-executive director. Executive director means who are working in a company on a day-to-day basis, daily basis, on an active basis. Executive director work in the company. Non-executive director do not work on daily basis. They do not work in day-to-day basis. Okay, executive director come to the company every day. They are completely involved with the company's affairs. Non-executive director are not completely involved in the company's affairs. So people, if I own a company, then I am an executive director. Then what will happen is, now this company is listed, public's money is involved, but I have started this company on my own from scratch 10 years ago. So basically, whatever decisions I will make in a company, some decisions can be based on emotional decisions, because this is my company. Now, any decision that I make may not be, maybe good, or maybe bad. Okay, so emotional decisions may not always be good, emotional decision may not always be bad. So if non-executive director are not involved in the company's day-to-day affairs, that means what? They do not care if the company is mine or not. They don't care. They will be super objective. They will be super clear as to what the company exactly wants, and is this decision really benefit the company or not in the long run and the short run. So if there is a combination of executive director and non-executive director, that means the company will have a independent, unbiased decision making process. Okay, So this is the reason why executive director are there and non-executive director are also there. Now, if the chairperson is a non-executive director, which means what? The decision taken by the board will be little unbiased. If the chairperson is a non-executive director, I will tell you. If the chairperson, if he is an executive director and if he is a non-executive director, that means what? Over here, biasness will be more, and over here, biasness will be less. Correct? Is everybody with me? Biasness will be less. Executive director, non-executive director. So, if the biasness is more, that means the more is a possibility of biasness, the more should be the number of independent directors. Hence, it is 50%. The less biasness is there, the less independent directors are required. That's the reason why 1/3 of independent directors are there. Are you guys with me? This is how you should study law, people. This is how you should study law. TC Power, are you guys with me? Everybody with me? Did you understand the logic behind why if a chairperson is a non-executive director, 50% should be independent director. If the chairperson is an executive director, 1/3 should be independent director. Are you guys with me? Yes, give me a quick thumbs up. Why? If a chairperson is a non-executive director. Yes, perfect, Ankesh. Perfect. Okay, all right. Now, listed companies must have 1/3 of the directors as independent directors. Public companies should have at least two independent directors. When should a public company have independent director? Paid up capital is 10 crores or more, turnover is 100 CR or more, outstanding loans, debentures or deposits is more than or equal to 50 CR or more. That's it, public company is done. Now, independent director's qualification. Independent director's qualification. Independent director should possess what all qualification so that he will remain independent. The first thing is he should not be a promoter or he should not be related to promoter. Second, he should not have any pecuniary relationship with the company. He can receive director remuneration. He can also make transactions with the company, but transactions should not exceed 10% of his total income. Perfect, Nandini, perfect. Hi, Veni, how are you? Next, he should not be KMP in the last 3 years. KMP means what? What is the meaning of KMP, people? Tell me in the comment section. Okay, he should not have any significant accounting transactions with the company in the last 3 years. Next is he can have voting power, but not more than 2%. Number 2, he should not be an executive director or any director of a non-profit company, and this non-profit company receives 25% of income from a company, then that he cannot be a director in that non-profit company. If he qualifies all the criteria, he will become an independent director. If an independent director falls vacant, the board must fill within 3 months. Is everybody with me? Quickly, let's revise. He should not be a promoter. He should not be related to promoter. He should not have any pecuniary, monetary relationship with the company, but he can receive director remuneration. He can do transaction. The transaction amount should not exceed 10% of the total income. He should not be KMP in the last 3 years. He should not make any significant accounting transaction with the company in the last 3 years. He can have voting. He can have voting power, but not more than 2%. That independent director should not be a director or executive director of a non-profit organization which receives 25% of income from the company in which the director is an independent director. Are you guys with me? If the independent director's position falls vacant, that position should be filled within 3 months. Is everybody with me? Just give me a quick thumbs up. Next, appointment of directors. Okay, guys, answer me this question now. XYZ, a public company, has recently witnessed significant growth with paid up capital increasing to 120 crore and turnover crossing 350 crore. Now tell me people, for a public company, what is the limit? Public company paid up cap should be more than equal to 100 crore or turnover should be more than 300 crore. So 100 crore has been crossed paid up capital. Next, the company board comprises only 5 directors. The company has been asked to appoint a woman director due to the recent provision of the Companies Act Rules 2014. Discuss the criteria for the mandatory appointment of woman director. So, first you have to write the facts of the case. Then what you have to write, tell me people. After you write the facts of the case, then you have to write what? You have to write the legal question involved. Then you have to write the provisions as to, yes, mandatory. Perfect, perfect, perfect. Analysis and conclusion. Okay, first you need to understand what the question is exactly asking. Then explain the provisions regarding the maximum number of directors and any potential adjustment that may have to be made. Now, let's talk about independent directors. We know that public companies should appoint independent directors. The paid up cap increases. Paid up cap is more than or equal to 10 crore or turnover is more than equal to 100 crore. So paid up cap limit is triggered. Hence, this company has to appoint 2 independent directors. This also you have to write. This is the answer for this question. Explain the provisions regarding the maximum number of directors and any potential adjustments they may have to make. Question will be asked in a tricky, difficult manner, but you just have to understand one thing. Exactly what is the provision that you have studied and what all provisions you can write in the answer. Understood, people? Perfect. Next, appointment of directors. ABC is a private company with 2 directors and its articles association specify that the number of directors should not exceed 5. One of the directors resigned and the company is considering appointing a new director. Now you have to give an explanation as to giving the procedure the company needs to follow to appoint a new director. Simple. Now let's understand the provision. People, are you guys comfortable with this structure or you want the old structure back? Okay, give me an answer. Till then I will continue with the question. Okay, now appointment of director, section 152. First director of a company. If the articles of association does not specify, the subscribers of the memorandum will become the first directors of the company. What is the meaning of subscriber to the memorandum? The ones who have started the company will be called as subscribers to the memorandum. In a one-person company, the sole member is the first director until a new director is appointed. Easy. Next, appointment of directors. Directors should be appointed at the AGM unless specified otherwise in the articles. Next, the director should have a DIN number, declaration and compliance before appointment. Proposed directors must provide the DIN and declare that they are not disqualified by law. We will understand the disqualification directors in the next few topics. So, director should give DIN along with declaration that he is not declared disqualified by law. Consent to act as director. Without director's consent, he cannot become the director of a company. So he has to give a consent along with filing the form DIR 12. Okay. Any decision that is taken by the company, it becomes official. When it will become official? When that company will file form with the register of companies, and that form is called as DIR 12. Tomorrow I have to be appointed as a director in a company. Company secretary, cost accountant or chartered accountant will file the form DIR 12 with the ROC that Balgopal Sridharan is going to be appointed as a director in the company. Every detail, all details of mine will be shown in the DIR 12. Is everybody with me? Let's quickly revise everything. Subscribers to the memorandum, if otherwise not specified, will become the first directors of a company. In OPC, one member, the same member will become a director unless otherwise appointed. Next, appointment of director should be done at the AGM. Director should have a DIN number. He should also give a declaration that he is not disqualified by law, and he should also give a written consent along with form DIR 12 has to be filed. Is everybody with me? Just give me a quick thumbs up, quick thumbs up, quick thumbs up. Now coming back to this question. ABC Limited is a private company with 2 directors and its articles of association specify that the number of directors should not exceed 5. People always remember one thing. Do not first read this case study question at all. In the exam, when case study questions are asked, do not read the case study questions first. First, what you have to do is, first you have to read this question. In the end, what exactly is the question trying to ask you? Your first focus should go over here. Again, I will tell you. Case study question will be lengthy, 5 to 10 lines, 20 lines, 30 lines. That will be complete. A big story will be told to you. But never ever read the entire story. Always read the last question. What exactly is the question trying to ask me? When you read that question, you will know what provision you have to use, what rules you have to mention, how to write the answer. Then you come to the facts of the case. Then you have to read the facts of the case. And that too, facts of the case you should read because you have to write it in the answer. Only for that purpose you have to read the facts of the case. People will give, the examiners will give you, ICMA will give you a long story. And then the question will be so direct that you know the provision, and then you will regret, why the hell did I waste my 15 minutes time in understanding the case study? Okay. So this is the trick that people use to confuse you. Is everybody with me? Just give me a quick thumbs up. Now, you have to write the procedure that company needs to follow to appoint a new director. Now, first directors of a company, in case of removal, means which form has to be filed. Okay, we'll see. DR 12 is only to be filed. Vijay, DR 12 is for appointment and removal of directors. Okay, if a director is getting resigned, the director is being removed, DR 12 form is filed. All right. Now, first directors of a company. You write this. You don't have to. Do you have to write this provision? No. You have to write which provision? You have to write this. This is your answer, people. This is your answer. Now, let's talk about rotational and non-rotational directors. Is everybody with me, guys? Is everybody with me? Just give me a quick thumbs up. Is everybody with me? All right. Perfect. Now let's talk about rotational and non-rotational directors. In public companies, at least how many directors have to be retired by rotation? 2/3 of directors should retire by rotation. The articles may specify a higher proportion to make all directors rotational. Articles can also tell that all the directors should be made rotational, or otherwise, if nothing is mentioned, 2/3 of directors should be liable to retire by rotation. Now, among those 2/3 of directors, 1/3 of rotational directors retire at each AGM. Okay, what is the meaning of retirement? Can anyone tell me in the comment section what is the meaning of retirement? Next, directors appointed by the government or financial institution are not rotational, because government and financial institution appoint directors so that company makes all the decisions very carefully. Company is not getting involved in a fraud. Company is not getting involved in a fraud. Hence the reason government and financial institution appoint a director. Now, if you ask those directors to retire, then what is the purpose of appointing a director in the first place, right? So, any director appointed by the government or financial institutions are not rotational. All right. Now, retirement and reappointment. At the first AGM, every subsequent 1/3 of directors retire. Okay. Retiring directors are those longest in office since their last appointment. Directors can be reappointed. Now, let's talk about reappointment of directors. When can a director be reappointed? Director can be reappointed unless these three conditions are complied with. Now, basically we are understanding when can a director cannot be reappointed. When can a director cannot be reappointed? Number one, the company decides to appoint somebody else. Number two, the company resolves not to reappoint that specific director. Or number three, the director becomes disqualified by law. That director does something which is against the moral turpitude, is involved in fraud. Hence, the company decides not to reappoint that director. So in 3 cases, directors cannot be reappointed. Number 1 is if the company decides to appoint somebody else. Number 2, the company resolves not to appoint that specific director. And number 3, that director is disqualified by law. Perfect. Now, vacancy due to returning director. If a returning director vacancy is not filled and the meeting has not resolved not to fill, the meeting is adjourned to the same day next week. Which means what? Retained director's vacancy is not filled. Retained director has left the company. Now his seat is vacant. Now the company has to fill that vacancy. The company, in the company meeting, they have not filled the casual vacancy. Then what will happen is that meeting will be adjourned to the same day next week. If today is Wednesday and today I am supposed to conduct a meeting whereby I am supposed to appoint the director, I have to fill the casual vacancy. So Wednesday, the meeting got adjourned to the next Wednesday of the same Wednesday. Oh, Wednesday of the next week. Wednesday of the next week. Okay. If still not filled, if in the adjourned meeting also the vacancy was not filled, then what will happen is the returning director is reappointed. Which means what? Even in the adjourned meeting, the casual vacancy is not filled, the returning director will be reappointed. This is the rule. Now, in what cases even that returning director will not be reappointed? Reappointment is rejected. Simple. Number 2, director himself says, I do not want to become a director of the company. Number 3, director becomes disqualified by law. And number 4, to reappoint the director, special resolution or ordinary resolution is required, but that resolution is not passed. In that case, that director will not be reappointed. And last is section 162 applies, which means what? In one resolution, multiple directors cannot be reappointed. There can be a rule that company, in the articles, that company may say that multiple 3 or 4 directors cannot be appointed in just one resolution. So this is the rule. So this is section 162. Multiple directors appointed in a single resolution. Hence, that single resolution is not possible. Hence, the director cannot be reappointed. Now, exemption from retirement provisions. Government companies, retirement provisions do not apply. And last, subsidiaries of government companies, if entirely owned by a government company, retirement provisions do not apply. Simple. Now, let's again revise it. In the adjourned meeting, the retained director will be reappointed. When he will be not reappointed? Number 1, if the board of directors reject his appointment. Number 2, the director himself rejects the appointment. Number 3, he is disqualified by law. Number 4, special or OR is required for reappointment of director, and that OR or SR is not passed. And last is single resolution, multiple directors cannot be appointed. Hence, for that reason, reappointment cannot be possible. Is everybody with me? Just give me a quick thumbs up. Nandini, Veni, Gauri, Tejasvi, Venkatesh Sharma, Chandrasekhar, Gopal sir, where are you? Anuradha, Rahul, Kanchan. Now, next topic, we're going to understand what are the disqualifications of the director. Perfect. Now, people, tell me the answer of this question. ABC is a private company with 2 directors, and articles of association specify that the number of directors should not exceed 5. One of the directors resigned and the company is considering appointing a new director. Discuss the procedure company needs to follow. Okay, the answer is done, people. The answer is done. Okay, done. So sorry. Next, when can a director disqualified from acting as a director? Section 164. Always remember this. Section 164. When can a director will be said to be disqualified by law? What all things he must be doing because of which the law has disqualified him to act as a director? Perfect, Anurag. Perfect. Amazing. Now, this can be the question. Possible question can be this in the exam. Mr. Raghav was appointed as a director of PQR Limited 6 months ago. After a recent review, it was discovered that he has been convicted of a financial crime and served a sentence of 1 year. Mr. Raghav's tenure has been productive, and the company is considering renewing his term at the next AGM. Analyze whether Mr. Raghav is eligible for reappointment as a director under the provisions of Section 164. What actions should the company take to comply with the legal requirement if Raghav is disqualified by law? People, tell me the answer of this. Venkatesh Sharma, Veni, Chandrasekhar Gopal sir, Anuradha, Rahul Kanchan, Tejasvi Pawar. Tell me the answer, tell me the answer, tell me the answer. Quick, quick, quick. Just give me answer in 5 to 6 words, guys. That's okay. I do not expect you to write a big answer. Just write answer in short, crisp, sweet answer possible. Yes, people. Yes, 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 yes. Give me answer quickly, quickly, quickly. I hope you're able to see the screen. And don't just try to answer the provisions. Okay. Unsound mind, not eligible as convict. Yes, Rahul Kanchan. This is the answer I was expecting. Yes, yes. Tejasvi Pawar, this Raghav is not of unsound mind. He is involved in financial fraud, financial crime. Hence, that can be reason for why he cannot be reappointed. Okay, now we're going to understand the disqualification, not allowed in. Veni. The main answer should be he is disqualified by law because he is involved in a financial fraud, not paid any cost. Okay, guys, hold on. We are not talking about the provisions. I'm just asking you simply, as per your opinion, what do you think the company should be doing? The answer is he is not eligible as he is convicted. Now we're going to understand section 164, disqualifications by law. Yes, a person is ineligible for appointment as a director. There are 4 conditions. Okay, 4 conditions. Number 1, mental and financial restrictions. He is of unsound mind, or he is declared as insolvent, or number 3, pendency of the insolvency proceedings is going on. Next, criminal and legal restrictions. He is imprisoned for 6 months plus 5 years have not over since his term of imprisonment has been completed. Disqualified as 5 years not elapsed from the date of conviction. Yes. Venkatesh Sharma, perfect. Next, if sentenced to 7 years, permanently disqualified, are disqualified by a court or tribunal, they say that this guy is disqualified by law because he is involved in a financial fraud. Next, corporate governance violation. He has not paid calls. He has defaulted for more than 6 months. And next is 188 violation in the last 5 years. In last 5 years, he violated RPD transactions, related party transactions provisions. Next, he does not have a DIN number. And last, he is already director in so many companies that he cannot become a director of another company. There is a limit that for how many companies a director can be a director in. He cannot be a director in more than 50-60 companies. Okay, so if he has touched the limit, he cannot become the director of any new company. This is corporate governance violation. Next, directors of defaulting companies, which means what? If he was being a director where the company has not filed financial statements in last 3 consecutive financial years, and number 2, the company has failed to repay deposits, redeem debentures, and declare dividend in the last 1 year, and such a director is disqualified by law for the 5 years from the failure date. Yes. Quickly, let's revise. Mental and financial restrictions, unsound mind, 2, insolvent. Number 2, criminal legal restrictions, 6 months imprisonment, 5 years have not been over since his imprisonment term has been completed. Number 2, he was imprisoned for 7 years. Number 3, court or tribunal has disqualified him by law. And next, corporate governance violation, 6, he has defaulted on share calls for more than 6 months. And number 2, he has violated section 188 in the last 5 years. And number 3, he does not have a DIN number. And last, he has already touched the maximum number of limit for which he should be a director. And next is directors of defaulting company. Financial statements not filed in last 3 consecutive financial year. And number 2, fail to repay deposits, fail to repay debentures, and fail to pay the dividend, fail to declare the dividend. Such a director is disqualified for 5 years from the failure date. Are you guys with me? Was it very, very easy? Was it very, very clear to you? Give me a quick thumbs up. Veni, that's completely okay. You do not have to delete the message. Veni, that's completely okay. We are here to make as many mistakes as possible so that we don't end up making mistakes in the exam. Okay, Veni? Guys, I would want you, sometimes I would want you guys to give me a wrong answer. To give me the wrong answer. Okay. Now, when we'll be solving MCQs, I will tell you one thing. When we'll be solving MCQs, I want you guys not to give me any correct answer. I want you guys to give me the most incorrect answer. That's going to be fun. Okay. Only for 2 questions we will do. And please, do not just pause the video and then leave. Otherwise, you will end up learning the wrong answers. Okay. Rahul, Kanchan, Tejasvi, fantastic guys. Fantastic. Perfect. Now, again, this section 164 subsection 2 does not apply to government companies. Private companies may impose additional disqualifications in their articles. All right. Now, vacation of director. Section 167 deals with vacation of director. A director's office shall become vacant under the following circumstances. What are the following circumstances? Let's understand. Disqualification under section 164. People, this is the disqualification that we are going to try to understand. If a director incurs any disqualification under section 164, what is section 164? We have just now studied. If disqualified under section 164, the office becomes vacant in all companies except the company which is in default. Can you guys tell me the logic behind why this rule has been made? If the director is disqualified under section 164, he should vacate his office in all the companies where he was director except for the company where the default has been made. Can you tell me the logic behind what could be the possible reasons for why this provision has been made? Can you tell me what could be the possible reason for why this provision has been made that says that the director incurs disqualification under section 164 subsection 2, he should vacate his office from all the companies in which he was director in except for the company in which he made a default. Pendency of case. Okay, Rahul Kanchan, you are very, very close, Rahul. You are very, very close. The logic behind this is, people, anybody else wants to answer this question? What could be the possible logic behind why this provision has been made? Can you guys tell me the logic behind why this provision has been made? If you do not know the answer, just drop me a thumbs up so that I don't have to wait, okay? Okay, just 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Okay, now let's understand the answer. People, if the director has messed up in one company, now punishment is that he should vacate his office in all the companies is punishment. Another punishment is if we ask him to leave the company in which he had messed up in to make the default correct, and such a negligence person should not. Perfect, Venkatesh Sharma, amazing guy, amazing. So in which company he made a default, it is his responsibility to clear the mess that he created, and then he will be disqualified by law. That is his main punishment, people. That is his main punishment. You have to be in that company in which you made the default. It is your duty to correct the mistake. It is your duty to clear the mess. Then you will be sent home. Venkatesh Sharma, amazing. Perfect, Venkatesh. Yes. Next is absence from board meeting. The director with having a leave of absence, without having a leave of absence, is not attending a board meeting in last 12 months, his office should be vacated. Next, contravention section 164, he enters 184, he enters into a contract in which he is interested in. He enters into, for example, I am a director in a company, I enter into a contract with my brother but I did not disclose to the directors in which I deal with, that saying that he is my brother, so let's deal with him. I am not at all disclosing that he is my brother when I'm dealing with the company. So this is a clear betrayal to the company, right? Company can deal with interested debtor, but interested debtor shall tell that he is my brother, and hence they have to make a proper disclosure, people. So if he has not made disclosure, that means he will violate section 184. Next, failure to disclose interest. If the debtor failed to disclose in any contract or arrangement as per section 184, yes. Over here, this talks about entering into contract. Over here, failure to disclose interest. Next, he is disqualified by court or tribunal. And last third, conviction and imprisonment. If convicted of any offense and sentenced to jail at least for 6 months, the office does not vacate in 3 situations. What are those 3 situations, people? Conviction or disqualification order is challenged, which means what, people? The director who was convicted of moral turpitude or convicted of financial fraud, financial scam, his office will not be vacated when 3 situations. Number 1, conviction or disqualification order is challenged, which means what? Court has ordered that I am convicted of financial fraud, but I know that I did not make any fraud. I was not involved in any fraud. So I am challenging the court decision. In that case, my office will not be vacated. Next is an appeal or petition is filed within 30 days and pendency and remains pending for 7 days after disposal. Same, appeal is pending. I have appealed against the court order that has told me that I am a fraudster. Number 3, if that appeal is also saying that, if the higher court is also saying that I am a fraudster, then again I will appeal against that court in Supreme Court, and this a further appeal is filed within 7 days and is pending. Okay. Next is remove if the director is removed as per the provisions of Companies Act. Cessation of employment. If the director if a director appointed due to holding a specific office or employment is in a holding, a subsidiary or associate ceases to, that means what, people? I am a director of Flipkart because I was a director in Walmart. I am a director in Flipkart because I was a director in Walmart. Now, if I am vacating the office from Walmart, then I should also vacate my office from Flipkart, because I was a director in Walmart. That is the reason why I am a director in Flipkart. Hence, if my office, for the reason why I am a director in Flipkart, is vacated, I have to vacate my Flipkart office also. Is everybody with me? Let's quickly revise. Disqualification 164. If data incurs any disqualification listed in 164, and number 2, he should vacate in all the companies in which, except for the one in which he has made a default. Number 3, if he was absent in the board meeting in the last 12 months, his office will be vacated. Number 4, he enters into a contract in which he is interested in, not allowed. Next, if he fails to disclose interest in which the director is interested in, court or tribunal disqualifies him by law. Conviction and imprisonment. In last 6 months, I was imprisoned. My office will not be vacated when appeal or I have challenge in the court. Next is I am removed from the company. And last is, if I am holding my office in Walmart, if I'm holding my office in Walmart, because of which I am a director in Flipkart. So the moment I vacate my office from Walmart, I have to vacate my office from Flipkart also. Is everybody with me? Just give me a quick, sweet, short thumbs up. Drop me a heart, drop me a thumbs up, saying that I am with you, sir. We are listening to you. And yeah, that's it. We are hearing you. Okay. Is everybody with me? Everybody with me? Quickly, people will complete this off. Okay. Yes. Give me a quick thumbs up. Give me a quick thumbs up. Yes. People, now I would want you to answer me this question. Pooja Gupta, thank you so much. Answer me this question. XYZ Limited, a listed public company, has a director, Mr. Mehta, who has been absent from all the board meetings in the last 13 months. 12 months triggered. The board is unsure about whether his office should be vacated or not. Board of directors are unsure whether this director will become a director or not. Explain the provision under section 167 regarding the vacation of office of a director in a case of absence from board meetings. What steps should the company take in this situation considering Mr. Mehta's absence? Guys, tell me the answer. Hi Devika, how are you? Where are you from? Guys, tell me the answer for this question. Answer me this question in 5 words. 5 words, 5 to 6 words, 7 words. Kerala, oh my god, amazing, amazing, Devika. Great, great, great. You know, it's such an amazing feeling when I see people watching from all parts of India. That's like, that feeling cannot be explained, people. That's such a beautiful feeling. 12 consecutive months absence. Perfect, perfect, Rahul Kanchan, perfect. And tell me, what steps should the company take in this situation considering Mr. Mehta's absence? They should ask the director to vacate the office with immediate effect. Perfect. Yes. Now, appointment of KMP, section 203. Company that are required to appoint KMP. Every listed company is supposed to appoint a KMP, and every public company whose paid up cap is more than or equal to 10 CR is required to appoint a KMP. Okay. What does KMP means exactly? KMP means MD, CEO, manager, or whole time director, CS or CFO. Now, this is very, very interesting provision, people. This is very, very interesting. That says a person cannot be a chairperson and MD or CEO at the same time. This says that a person cannot be a chairperson plus MD and CEO at the same time. Why is this rule made? Can anyone tell me quickly? But this, people tell me this, tell me the answer of this. Till then, I'm continuing with the provision so that we don't waste time. Okay. All right. If you do not know the answer, just give me a thumbs up. If you know the answer, just drop your answer. At least, people, I would want you to attempt this question. Okay. The more you will hammer your brain to think, your thinking ability will improve. That will improve drastically. Okay. This is called as problem solving skills, people. Problem solving skills. You need to understand what could be the possible reason. Just think about it. Just think about it. What could be the possible reason for why this provision has been made that says MD cannot be a CEO, sorry, chairperson cannot be a MD or CEO at the same time. Now, this provision is not applicable when articles of association allows, and number two, the company does not carry multiple business. The company is only carrying one business. In that case, a person can be a chairperson and MD, CEO at the same time. Now, this provision again does this provision limit that says that a chairperson cannot be MD and CEO at the same time. This provision is not applicable when the company has got multiple business, multiple divisions, and each division have got CEO. In that case, it is allowed. Can you tell me the possible logic behind this rule? Till then, I am trying to explain you the next concept. After we cover the next concept, if I do not receive the answer, I will explain it to you. Okay. All right. Conditions for appointment of KMP. The appointment should be made through board resolution specifying what? Terms, conditions, and remuneration. Next, restriction on holding KMP roles. A whole-time director cannot hold office of KMP. A whole-time director cannot be a, okay, a person cannot be a CS in more than 2 companies. A person cannot be a CS in more than 1 company. A person cannot be a whole-time director in more than 1 company. A whole-time KMP cannot hold office in more than 1 company at the same time except in its subsidiary company. Now, we know that, sorry, people, I told you whole time director, it's wrong. Okay, I was trying to tell you what MD, CEO, manager, or whole time director, CS and CFO. Understood, guys? People, one second. Manager in case of whole time director. Perfect. Yes. Yes, this rule says that a whole time KMP cannot hold office in more than one company. Guys, are you able to answer the question? Are you guys able to answer the question? A whole time KMP can hold office if it's a subsidiary company of the holding company. It's absolutely allowed. Next, managing director or manager in multiple companies. A person can be appointed as a managing director or manager in up to 2 companies, subject to what? Subject to unanimous board approval, which means what? All the board all the board of directors should say. Give me 1 second. All the board of directors have to give approval, saying that yes, this managing director or manager can become MD or managing director in more than one company. Plus, prior approval to all directors in India is required. And last is, any casual vacancy should be filled within 6 months. Now let's quickly revise. Board resolution is required specifying the terms, conditions, and remuneration. Number 2, a whole time KMP cannot hold office in more than one company except if it's a subsidiary company. Next, directorship in another company. A director can be appointed as a MD or manager in more than, a person can be appointed as MD or manager in more than one company, but subject to what? Subject to conditions. Unanimous approval of board is required, and number two is prior notice to all the directors is required. This rule is very important. That says that a KMP can serve as a director in another company provided he has obtained the board's approval. All right, now let's come back to this logic over here. Is everybody with me, guys? Just give me a quick thumbs up. Give me a quick thumbs up. Yes, Venkatesh. Perfect. So people, the reason why this rule is made, that says that a chairperson cannot be MD or CEO at the same time, but company does not carry multiple business. It's a small business, so it is allowed. But this is very important. Already people, let's say, take an example of Walmart. Let's say I am already a MD plus chairperson in Walmart. I'm actually not allowed. The company is involved into multiple business, but over here, what the criteria is saying is, if the company has got several divisions and each division has already got a CEO, Flipkart has already got a CEO, Myntra has already got a CEO, Jebong has already got a CEO. In that case, if CEO's work is already outsourced, then you can become the MD and chairperson of the main holding company. Then it is allowed. All right, perfect. Next, payment of remuneration to directors and KMP and disclosure requirements. So, directors including MD, hold director and manager should be paid how much remuneration? Maximum 11% of net profits remuneration should be payable. Next, if there is a one managing director, one hold director, one manager, how much remuneration can be paid to that one person? Maximum of 5% of net profits. Number 3, if there is more than one managing director or whole time director or manager, maximum how much can you pay from the net profits? 10% of net profits you can pay collectively. And next, directors who are neither MD nor whole time director, but whole time director and MD exist. In that case, how much can you pay to that person who is neither an MD nor whole time director? Maximum of 1% of net profits. And last is directors who are neither MD nor Holton letter, and Holton letter or an MD do not exist, in that case 3% of net profits you can pay to that person. Now, overall maximum remuneration. Now, in case the company has defaulted with the banks, the company has defaulted with the financial institution, the company has defaulted with the secured creditors, prior approval from these people is required to pay maximum remuneration to those people that we just understood. Next, the auditor must certify that remuneration paid complies with the provisions. Auditor should certify that whatever remuneration that we are paying is complied with section 197 subsection 1. Is everybody with me? Give me a quick thumbs up. Venkatesh, Rahul, Kanchan, Devika, Tejji Pawar, Pooja, Veni, Chandrasekhar, Gopal sir, Gauri, give me, Anuradha, give me a quick thumbs up. Perfect, Vini. Veni, Venkatesh, Rahul, Kanchan is with me. Devika is also with me. All right. Now, next is computation of net profit. How will the net profit that just now we understood, how will that net profit be computed? Net profit will be computed as per section 198. Section 198 says what all things you can include while calculating, what all things you cannot include while calculating. So over here, remuneration, while calculating the net profit from section 198, remuneration will not be deducted while calculating net profits as per section 198. Now comes a very amazing concept. Remuneration rendered in any other capacity. Now that we have understood these people can be paid, let's take an example of one managing director. He can be paid maximum 5% of net profits. One managing director, Holden director, manager. He can be paid maximum of 5% of net profits. Now, apart from this, some people tell me, can this person be paid remuneration more than 5% of net profits? Can this person be paid more than 5% net profits without special resolution? Tell me, without special resolution, can this person be paid more than 5% of net profits? Yes or no? Quickly answer me. Rahul Kanchan says yes. Perfect, Rahul. Perfect. Yes. Now, people, this director is getting remuneration because of his director's role and responsibility. Now, what if he is providing any professional service? Is providing any other service? If he is providing any other service, still whatever service we will provide, still that whatever service will be considered under section 198 calculation only. He should not be paid more than 5% unless two situations arises. Which situation? Articles of association say that he should be paid remuneration, and number two, a resolution passed in a meeting or if required by a special resolution at the general meeting. This is not required. This we already know this. Now, this is important. Remuneration may include compensation for services rendered in any other capacity, unless, which means what? You give any service, whatever service you provide, for whatever you income that you will receive, that all income will be should not be more than the limit we understood. But this will not be applicable when the service is of professional nature. He's really giving legal services, legal advisory services. And number two, nomination remuneration committee or board determine that the director possesses a professional qualifications. Then in that case, he can be given remuneration, and that remuneration will not be calculated, will not be included in the 5% criteria. Understood? Is everybody with me? Is everybody with me? Just give me a quick thumbs up, guys. Give me a quick thumbs up. I'm moving forward, okay? Now, sitting fees. The sitting fees is also not included in the remuneration, and the sitting fees should not be more than 1 lakh rupees. Sitting fees is not included. Now, in what ways the remuneration can be paid to the director? He can be paid monthly payments. Number 2, he can be paid net profits. Number 3, combination of both. Now comes another important thing. If a company is afraid that this director will be involved in a fraud, this director will be negligent, so the company takes life insurance policy, so that tomorrow if company suffers a loss because of this director, then what will happen? The company will be into complete loss, right? So to protect itself from loss, the company pays insurance premium to the insurance company. Now that company cannot tell the director that, bro, see, we are paying insurance premium because we are afraid that you will be negligent in the future, and because of you the company will suffer a loss. Hence we are deducting your salary with the insurance premium. The company cannot say that. Insurance premium paid for fidelity guarantees and against misfeasance and misgovernance are not considered as part of remuneration. Next, if company does not have any profits, the company has got inadequate profits, company suffers a loss, company can still pay remuneration provided they comply with Schedule 5 conditions or they get approval from the central government. Next, if the company pays in excess of the limit that we understood as remuneration to the directors, the director has to return that money back to the company within 2 years. But until 2 years, the director cannot say that I've got 2 years time, so I will utilize the money in as per my whims and fancies. Director cannot do that. Director has to take care of that money as if he is a trustee of the company. Is everybody with me? Give me a quick thumbs up. The company can waive recovery by special resolution within 2 years. So just now we understood payment of remuneration to directors and KMP and disclosure requirements. So company defaults in banks, financial institutions, secured creditors. Prior approval from the banks, secured creditors is required for passing a special resolution to pay to the director. Number 2, the auditor shall certify by calculating the limits specified under section 197. Next, net profit should be calculated as per 197, and in that net profit, remuneration should not be deducted. Next, remuneration is determined by company's articles of association or a resolution passed by the company via special resolution. Number 3, remuneration may include compensation for services rendered in any other capacity, but it will not include services of professional nature or if the nomination remuneration committee determines. Next, sitting fees is also not included in the remuneration. Sitting fees should not be more than 1 lakh rupees. Now, directors can be paid remuneration through monthly payments or percentage of net profit. If company has got inadequate profits or no profit, company can still pay provided they comply with Schedule 5 conditions or they get central government's approval. Now, even if the company pays excess remuneration of the limit, then the director has to repay. The director has to return the money back to the company within 2 years. Until then, he has to take care of that money as if he is a trustee of that money. Company can waive the recovery by passing a special resolution within 2 years. Now, disclosure by listed entities. Listed companies must disclose in the board report about the ratio of each director's remuneration. If any employee is receiving remuneration for more than 1.25 CR, the name of the employee and all the details as to designation, remuneration, qualification, experience, and all the relevant details have to be disclosed in the board report. Next, if any employee has received 8.5 lakhs per month in any part of the financial year, that should also be disclosed in the board report. If an employee receives more than whole-time director or managing director or manager plus he is holding 2% shares in a company, that should also be disclosed in the board report. Now, if the director receives any commission, that should also be disclosed in the board report. Now, auditor should give a statement that the company has complied with section 197 while paying remuneration to the directors. Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up. Yes, people. Yes. Give me a quick thumbs up. Rahul Kanchan, Tejasvi Pawar, Anuradha, Devika, Veni, Venkatesh Sharma, Pooja. Yes, perfect, guys. Perfect. Chandrasekhar Gopal sir is not there. Pooja is not there. All right, perfect. Let's continue. Restrictions on powers of board, which means what, people? That just because a person is a board or director of a company, he cannot. Hi, Vishal Kumar Burma. How are you? Where are you from? Okay, Abhinitra, super amazing. Now, people, just because a person is a director in a board, he cannot take all the decisions. There are some decisions that should be only taken by shareholders. Now, what are the decisions? The board can only exercise certain powers with the consent of shareholder through a special resolution. What are those decisions? All right, Chandrasekhar Gopal sir. Perfect. Selling or leasing companies undertaking, we will require shareholders approval. Shareholders require shareholders approval to sell, lease, or dispose of the whole or substantially the whole of the undertaking, company's undertaking. Now, exception is, people, which means what? If the director, without taking shareholders approval, has sold a substantial undertaking to a third party, that transaction will be invalid. That transaction will be void. Now, this transaction will not be void when the buyer of that undertaking was acting in a good faith and he did not know that the director was acting beyond the powers. Number two, this provision does not apply if the company is in the business of buying and selling of land. It is a day-to-day activity of the director to buy and sell the land. Then it is not a problem. Now, next, investing compensation from merger amalgamation. The company has merged into with other company. Company has acquired another company. Due to some corporate actions, the company has received a lot of money, and that director cannot invest that money into trust, invest that money into securities. That decision can only be taken by whom? Shareholders. Correct. Next is this rule is not applicable to a private company. Next, borrowing money. Director cannot borrow money on behalf of the company more than the company's capacity. What is the company's capacity? Aggregate of paid up capital, free reserves, and securities premium, which will obviously require shareholders' approval. Yes. Next, exceptions. When does this rule does not apply? When it is short-term loans from banks are excluded up to 6 months loans, it is excluded. If it is a capital expenditure, if the loan is taken for capital expenditure, then that loan cannot be taken by a director without taking shareholder approval. If that loan crosses more than paid share capital, free reserves, and sec premium (SP). Now, temporary loans like cash rate bill discounting do not count for this limit. Small loans will not count for this limit. Now, remitting or giving time for debt repayment by director. Director has taken a loan, exorbitant loan he has taken. Now the other board of directors are telling him that, bro, it's okay. Instead of paying within 6 months, you pay me within 10 months or 1 year. That cannot be done without taking shareholders' approval. Just because you are a director, you have to treat the money as if the money belongs to shareholders and not yours. So, in four things, in 4 situations, shareholders' approval will be required, which cannot be taken by directors alone. Selling or leasing undertaking, exception is the buyer's title remain unaffected if the buyer acted in good faith, or if the company is in the ordinary course of buying and selling of land. Number 2, company has received money, they cannot invest in trust or securities without taking shareholders' approval. Number 3, director cannot borrow more than the paid share capital, free reserves, and securities premium without taking shareholders' approval. This is not applicable to short-term loans or temporary loans. Next, limiting or giving time for debt repayment by director. That's it. Now we're going to understand last few topics, then we'll be done, people. That's it. 15 minutes, we'll be done. Shareholders intervention in board functions. There are some situations where shareholders have to intervene in the board function. What are those situations when that will demand shareholders to intervene in the board functions? Number one, board of directors have got malafide intentions. Board of directors are like Vijay Mallya, they are doing fraud in a company. Number one, board of directors are incompetent of the board. Board of directors are incompetent people. They're not able to function properly. And number three, deadlock situation have arisen, because of which there is a tie in the decision making. There is no majority decision making. Hence, shareholders have to intervene. So in three situations, shareholders have to intervene in the functions of the board. Number one is malafide intentions of the board. Number two, board is incompetent. Number three, deadlock situation. Is everybody with me? Just give me a quick thumbs up. If I'm going too fast, just let me know. I will slow down my pace. Next, let's talk about related party transactions. What do you mean by RPT? RPT means dealings with directors, promoters, or KMP, and their related entities are called as RPT. These transactions require shareholders' approval. Unless, when will RPT transaction will not require shareholders' approval? If it is conducted in the ordinary course of business, plus it's in arm's length price, and holding company can enter into RPT with its wholly owned subsidiary company. In that case, it is allowed. So in two cases, RPTs will not require shareholders' approval. If the transaction is in ordinary course of business, plus it's an arm's length price, and number two, the transaction is done by a holding company with its wholly owned subsidiary company. All transactions must be disclosed in the board report. If not ratified, the contract is voidable and the beneficiaries must indemnify the company. Which means what? All the transactions should be disclosed in the board report. Otherwise, if not, okay, the transaction, if it is not approved by board, if it is not approved by the shareholders, let's say 5 directors are there in the company, one director enter into RPT with his cousin brother. Now the cousin brother have benefited a lot because he was a director in a company, and that director was using company's funds to benefit that person. Now what will happen is the board of directors, let us say that you cannot enter into a transaction with a cousin in such a small amount, you have to ratify us, you have to repay us back. Then the cousin brother have to repay all the benefit that he has received back to the company. Next, is everybody with me? Just give me a quick thumbs up. Just give me a quick thumbs up. Pooja Gupta, Venkatesh Sharma, Chandrasekhar Gopal sir, Abhinetra, Vishal Kumar Burma. Vishal Kumar Burma, where are you from? Rahul Kanchan, Tejasvi Pawar, Anuradha, Veni. Everybody just give me quick thumbs up. Now let's talk about provisions for RPT, a related party transaction, section 188. The transaction that will require compulsory board approval. What are the transactions? Sale, purchase, supply of goods or materials. Number 2, buying, selling, disposing of property. Number 3, leasing property. Number 4, availing, rendering services. Number 5, appointing agents for transactions. Perfect guys. Appointment of related party to a office of profit, which means what? I am appointing that cousin brother in my company. And number 7, underwriting, which means what? Promise to buy leftover of shares. We understood in the SEBI regulations chapter. The company has prescribed minimum paid up capital, exceeds specified transaction limit, prior shareholders approval is required. Okay. A company must obtain board approval for XYZ transactions. Okay. Now we understand. When will omnibus approval be granted? How will the omnibus approval will be granted? Can anyone tell me what is the meaning of omnibus approval? Can anyone tell me what is the meaning of omnibus approval? Over here, we understood if the company has got a minimum paid up capital or exceeds the specific transaction limit, prior approval of shareholders is required. If the company exceeds the transaction limit, prior approval of shareholders is required. Now, let's talk about omnibus approval. What is the meaning of omnibus approval? 100% approval. Okay, Pooja Gupta, perfect. Can anyone else, does anyone else want to give any answer? Pooja Gupta, omnibus approval means blanket approval. Normally what happens is, always audit committee reviews the RPD transaction. They will tell to the board that they can proceed or not. Okay, every time audit committee is involved while granting approval for the related party transactions. So every time it is not possible to continuously get the permission of audit committee. In that case, audit committee will tell that if you follow these 4 limits, then then our approval is deemed. That means what? You don't have to get approval for a transaction if it is falling under the specified limits or specifying conditions. The transaction is following the specified conditions, then it is not required for our approval. That is called as omnibus approval, that is blanket approval. Blanket means free. You can enter into transaction for free, provided the transaction follows the certain conditions. What are the conditions? Let's understand. The audit committee will tell that you enter into any transaction, RPD, but ensure that not any RPD people, there is a term called as recurring RPD, which means what? Buying, selling goods. Buying or selling goods. Companies into the business of, let's say, goods and services. Manufacturing of goods. Let's cut the services part. Manufacturing of goods. So raw material requirement is that. So continuously, if the company deals with RPD transactions, let's say every month 5 to 6 transactions are done through RPD. That means what? Is it possible for every time the audit committee to give approval? No. So audit committee, what it does is, it will give conditions. What can be the maximum transaction value for the year? And number 2, maximum value per transaction. Regular reviews of all the transactions will be done. And last is, transaction that exceeds 1 crore may still be approved if it is unforeseeable. Which means what? Certain transaction can be beyond our control. Then you have to enter into a transaction, and that transaction is called as exceeding 1 CM, and when it still be approved if condition is unforeseeable. So audit committee will give conditions as to when can you say that this transaction can be valid and will be approved. You don't have to come to us for continuous permission, for continuous approval. Next, what is the criteria for a transaction to be a omnibus approval transaction? Transaction must be a repetitive transaction, and it should be companies in the best interest. So 2 conditions should be followed. The transaction should be repetitive in nature, and number 2, that transaction should be in the company's best interest. Next, approval must include details like party names, nature, duration, and value of transaction. All the details you have to mention. Now, omnibus approval, is it valid for 1 year or is it valid for permanently? It is only valid till 1 year. Next, cannot be granted for transaction that involves sale or disposal of companies undertaking. So if it's buying and selling of goods, it is allowed. If you are buying and selling companies undertaking, that transaction cannot come under the purview of omnibus approval. Is everybody with me? Just give me a quick thumbs up. Pooja Gupta, Tejasvi Pawar, Devika, Veni, Rahul Kanchan, Chandrasekharan, Gopal sir, Abhinetra, Vishal Kumar, Burma. Just give me a quick thumbs up. Now we're going to understand, when will the threshold be for, when will related party transaction requires shareholders approval? Now we're going to understand. If there is a sale or purchase of supply of goods or materials where it exceeds 10% of the turnover or 100 CR, whichever is lower. Number 1 is sale, purchase or supply of goods or materials which exceeds 10% of the turnover or 100 CR, whichever is lower. Number 2, buying and selling of property. Again, same condition, 10% of net worth. Over here, people, net worth is mentioned. Net worth. Buying, and if the property is involved, you have to understand that this is net worth. If it is buying and selling of property, 10% of net worth or 100 CR, whichever is lower. If it is leasing property, again, if property word is involved, you have to take into consideration that net worth will be involved. Okay, so leasing of property, if it exceeds 10% of net worth or 100 CR, then transaction will require shareholders approval. Now, availing or rendering services, in that case 10% of turnover, but 50 cr, whichever is lower. Over here 50 cr. When it's a services, it will be 50 cr. When it's a property, it will be net worth. Always understand this. If other transactions, appointment for place of profit, monthly remuneration should not exceed 2.5 lakh, which means what? I am a director in a company, I'm appointing a cousin, brother in my company, and I'm paying more than 2.5 lakhs per month, then that will require shareholders approval. Underwriting securities, if I am promising to buy the leftover shares, then and that transaction will exceed 1% of net worth, then I will require shareholders approval. That's it, guys. That's it. Let's come back to the MCQ part. MCQ part. We have spent 1.5 hours in this big chapter, people. Okay. Let's come to the MCQ part. Remaining 2 chapters are super small. We'll complete it off quickly. Okay. Let's come to the MCQ part. Are you guys ready for the first MCQ? Which class of companies must appoint at least one woman director? All private companies, listed companies, and public companies with paid up capital more than 100 cr or turnover more than 300 cr, one person company or section 8 company. What is the answer, guys? Give me answer quickly. Give me the answer quickly, guys. One B, one B, one B. Tejasvi Pawar saying one B. Yes, perfect, guys. Perfect. Abhineta Tejasvi Pawar, Rahul Kanchan, Gauri, Chandrasekhar Gopal sir, Abhineta Pooja Gupta. Amazing, guys. Amazing. Now, next question. What is the maximum number of directors a company can appoint without a special resolution? If you guys want more difficult question, let me know. After this, we are going to solve the most difficult question. 2B. Perfect. Yes, guys. Tell me this one. Which of the following is not a disqualification for a director under section 164? Being an undischarged insolvent, holding shares in another company, defaulting on filing financial statements for 3 consecutive years, conviction with a 7-year imprisonment. What is the answer of this? Perfect, Chandrasekharan Gopal sir, perfect. Pooja Gupta, amazing. Abhinitra, amazing. Correct, guys. Correct. Absolutely right. Rahul Kanchan also, amazing, guys. Amazing. 3B? Yes, perfect. Now we'll try to find a difficult answer, difficult question. Can anyone answer me this question? Gauri, Rahul Kanchan, Pooja Gupta, Devika, perfect, guys. Amazing. Can you guys tell me the answer of 5th question? I just want to know if you are able to remember the section or not. Abhinetra, B3, amazing. Anuradha, perfect, guys. Perfect. Pooja Gupta, Pooja Gupta also answering the easy question. Okay. Pooja Gupta, that's amazing. 5A, Rahul Kanchan, 5A. Are you sure? Yes, Rahul. Yes. Perfect. Guys, I will tell you one mind trick, okay? This is just a short glimpse of how to remember the section. When you think of 49 number, are you able to visualize 7 by 7 Rubik's Cube? When you hear the name 49, are you able to visualize 7 by 7 Rubik's Cube? People, I'm just taking your 2 minutes time just to give you a glimpse of how to remember the section that you will never ever forget. Yes, sir. Yes, yes, yes. Now, what you have to visualize is, let's take a word of independent. Independent means Mahatma Gandhi. Mahatma Gandhi is a freedom fighter who gave us independence. Okay. So imagine Mahatma Gandhi, sir, Mahatma Gandhi ji, solving 7 by 7 Rubik's Cube, and he is in a car. Mahatma Gandhi is solving 7 by 7 Rubik's Cube, 7 by 7 because 49. Mahatma Gandhi, independent, is solving 7 by 7 Rubik's Cube, is in a car. Why car? Because car has got 4 wheels. So whenever you hear the name car, you should know that car stands for 4. Which means what? Mahatma Gandhi, independent, 7 by 7 Rubik's Cube, 149. And 4 by, and car is 4, 149 subsection 4, independent director. So tomorrow if I ask you what is section of independent director, you should always visualize this weird scenario. Okay, I'm going to give you some weird scenarios that you will never ever forget. So Mahatma Gandhi solving 7 by 7 Rubik's Cube, he is driving a car because car stands for 4. This is how you should remember the section, people. I'm going to give you a lot of weird scenarios so that my goal is, after you complete the marathon, I will shoot one video for you, or I will come live in front of you. I will tell you how to remember the sections so that you will never ever forget. Tomorrow, if your son is also doing CA, CMA, you can be tell him how to remember this section. Siddesh ready? Yes, guys. Is everybody with me? Is everybody with me? Are you able to visualize the scenario that I taught you? Give me a quick thumbs up, guys. Give me a quick thumbs up. Yes, sir. Yes, sir. Okay, perfect. TSC Pawar. All right, all right. So with this, let's begin our next chapter. That is, so this is done. This is, guys, let's take a break of, do you want a break? Let's take a break of 10 minutes and then we will resume, okay? We'll resume back with again full of energy, super exciting, okay? All right, guys, all right, let's take a break of 10 minutes. I will see you in the class at 8 p.m. break. Yes, people. Yes, yes, yes. Is everybody with me? People. Is everybody with me? Let's begin our next chapter with full of energy, excitement. Yes, people. Yes, yes, yes. Perfect. Teji Pawar. All right. Anuradha, Vaini, Gauri, Devika, Pooja Gupta. Come back again. Quick, guys. Pooja Gupta, Abhinetra, Gauri, Rahul Kanchan, Chandrasekharan Gopal sir. Come back quickly, guys. Yes, guys. Are you ready? Are you ready? Are you ready, guys? Yes. Are you guys ready? Are you guys ready? Are you guys ready? Yes. Anuradha, Veni, Gauri, Devika, Pooja Gupta, Rahul Kanchan, Chandrasekhar Gopal sir, please come back. Please come back. Quick, guys. We'll start in one. Devika, amazing. Okay. So let's get started. The chapter of accounts and audit, people. Accounts and audit. Quickly, I have summarized these notes in such a beautiful manner that you don't have to put a lot of stress in your mind as to what is written. Okay. I've included a lot of tables. I've included a lot of flowcharts so that we can understand this chapter in the most beautiful way possible. Now, first topic is, people, appointment of auditors. Exam in exam question we asked, explain the procedure for appointment, rotation, reappointment of auditors under section 139 of Companies Act 2013. Also discuss the role of the audit committee in the process. You do not have to get scared by looking at the question. Okay, let's understand. Section 139 deals with appointment of auditors. It applies from, okay, let's forget about it. Now, people, tell me, this notes is super crazy notes, difficult to read, difficult to understand, lot of stuffs going on here. Now let's look at a simplified notes, a mind map. Does this sound super cool? Perfect. Yes. Section 139 deals with appointment, rotation, reappointment of auditors. Before that, we studied about directors. When will a director, how will the director be appointed? How will the director be resigned? How will the director be disqualified? Over here, we're going to understand about auditors. All right. Perfect. So let's begin. The first topic is initial appointment. So when will the auditor be appointed? At the AGM. Who is going to appoint the auditor? Huh? Who is going to appoint the auditor? Who can be appointed as auditor? Auditor can be individual or auditor can be a firm. What will be the tenure of the auditor? Tenure of the auditor will be 5 years. Selection procedure as per the Companies Audit and Auditors Rules 2014. Now let's understand, how will the auditor be appointed? What is the manner of selection? Company with audit committee checks the qualification, checks the experience of the auditor, checks if the auditor is going to handle the audit of company with such a huge size, or if there is any pending cases against that auditor in Institute of Chartered Accountants of India. All these things will be checked by whom? Audit committee. If there is an audit committee, if there is no audit committee, board of directors does the same work. Very easy. Now, special cases, pending professional proceedings, company can ask additional information about the auditor. Next, if board agrees, recommends the auditor to the shareholders. Obviously, shareholders going to appoint the auditor, and if the board disagrees, sends it back to the audit committee. But if committee still insists, board must propose it to AGM anyway. Okay. First things first, audit committee. Audit committee will recommend to the board of directors. Now, board of directors, if they agree with the audit committee, they will send this to AGM approval. If they do not agree, then they will give reasons. Then audit committee will appoint another person, will suggest another person. If the audit committee says no, this person is really good, then the board has to anyway give it to the AGM along with the reasons for why board does not agree with the audit committee. Simple people, very simple. Rahul, Kanchan, Veni, Devika, Tejasvi, Pawan, Anuradha, Gauri. Is everybody with me? Very easy. Just give me a quick thumbs up, guys. Just give me a quick thumbs up. Devika, Veni, Rahul Kanchan, Tejasvi Pawar, Anuradha, Gauri, Pooja Gupta, Chandrasekhar Gopal sir, Abhinitra. Where is Abhinitra? And where is Atul? PS. All right, all right, all right. Next, auditor written consent and certificate by auditors is required before appointment. The board must get a written consent and the eligibility certificate by the auditor. In that certificate, what all things will be mentioned, people? Number one, auditor is not disqualified under Companies Act or Chartered Accountants Act. Number two, the appointment is within the term limits. Number three, appointment is within the prescribed limits, which means what? He is already auditing more than 20 companies. Can he audit the 21 company? No. Pending cases has been disclosed by the auditor and compliance with section 141 eligibility rules that we are going to understand in the later part of the chapter. So, certificate must contain 5 things. Number 1, disqualification. Number 2, term limits. Number 3, prescribed limits of audits. And number 4, pending cases involved. And last is 141 section, eligibility limits. Next, inform ROC by filing. I told you people, any decision taken by the company will become an official decision when it will file that with the ROC. So it have to inform ROC within how many days? Within 15 days of the AGM where the appointment is made. Always remember, auditor will be appointed at the AGM by the shareholder. Hi Atul PS, how are you? Were you watching the lecture or just now you came after having your dinner something? Also required for reappointment. AGM approval is also required for not only appointment but also for reappointment. Now term limitations. If it's an individual auditor, the term limit is 5 consecutive years. After 5 consecutive years, we're going to understand how much period break he will take. If it's audit firm, 10 years, 2 terms of 5 years. Easy. Next, who must follow these term limits? If it's an unlisted public company, paid up capital should be more than 10 crore. Then the company has to follow the limits. Number 2, if it's a private limited company, paid up capital should be more than or equal to 20 crore. If any other company, public borrowings or deposits should be more than or equal to 50 crore. If in these companies auditor is appointed, then that company has to follow this term limitations. Very, very easy. If it's an unlisted public company, paid up capital should be more than or equal to 10 crore, then they have to follow that limits. Private company, paid up capital is more than 20 crore, they have to follow that limit. Or any company whose borrowings or deposits is more than or equal to 50 crore, they will have to follow that limits. Next, cooling off period. If it's an individual auditor, after doing audit for 5 years, they have to take a break of 5 years before reappointment. If it's an audit firm, they will have to wait for again 5 years. Plus, this is very, very important. Which means what? ABC is the auditor of Reliance for 10 years. Now, EFG is the auditor of Reliance. A partner of ABC cannot join EFG till the appointment term is complete. No firm with common partners allowed to replace the outgoing firm for 5 years. Next, transitional compliance. Old companies existing before 1st April 2014 had to comply by first AGM after 3 years. Okay, this is not relevant because it was of 2017. Now next, resignation and removal of auditor. If an auditor has to resign, then auditor must file a proper disclosure. Company has to appoint a new one. As per the rules, company has to file which form? ADD3 within how many days? Within 30 days of the resignation of the auditor. If the company wants to remove the auditor, then what they have to do? They have to require central government approval. The central government says okay, then they will have to remove the auditor by passing a shareholders approval. Special resolution required. Over here, the procedure should be board resolution, then approval of central government. Number 3, the central government will give opportunity of being heard to the auditor. Auditor will raise his concerns, raise whatever is going on in his mind. Why is he leaving the company? All the reasons will be given detail to the central government, and then shareholders approval will be required for removing the auditor. Very easy. Next, rotation of auditor. Shareholders may demand that in an audit firm, not one auditor should do the audit for 5 years. Shareholders can demand that in first year, if A has done the audit, in second year we want B to do the audit. Number 2, multiple auditors. Members can appoint more than one auditor. Obviously, shareholders can appoint more than one auditor in a company. Government role. Central government can make rules on rotation. If a partner leaves and joins another firm, that new firm cannot audit for 5 years. Very easy. Rule this is the same rule. If ABC, a partner, joins EFG, then EFG is ineligible to do the audit of Reliance. Cannot be the auditor of Reliance. Next, first auditor. Normal companies, board has to appoint auditor within how many days? Within 30 days of what? Incorporation. If not, shareholders have to appoint auditor within 90 days. Where? In EGM. EGM means, people, what is the meaning of EGM? Can anyone tell me the meaning of EGM? Can anyone tell me the meaning of EGM? Can anyone tell me the meaning of EGM? If it's a government company, CAG appoints within how many days? 60 days. If it's a normal company, 30 days. If it's a government company, it's 60 days. Before you write the exam, people, before going for the exam, just read this notes from the table. Your work will be super easy. Your study will become, your revision will become super easy. You don't have to go through all the lengthy test. Just understand the basic rules. I am assuming that you have already learned the notes in detail. Yes, Pooja Gupta, perfect. I'm assuming that you have already read the notes, and after that you are sitting for marathon. So every time and again, you don't have to go through all the lengthy notes. Okay. Yes, Tejasvi Pawar, perfect. Pooja Gupta, why are you dating the message? Tejasvi Pawar, perfect. Now, filing casual vacancy, section 139, subsection 8. Any reason except resignation, board fills within 30 days. If resignation, then board appoints, but shareholders must approve within 3 months in general meeting. If the auditor is resigning, then the board has to appoint another auditor, but it will require whose approval? Shareholders' approval is required. Within how many months? Within 3 months of general meeting. If there is any other reason except resignation, auditor has died, then the board can appoint within 30 days. Okay, very easy. No, Pooja Gupta, I did not ask you the meaning. I just asked you the full form of extraordinary general meeting. Okay, sorry, EGM. Okay, Pooja Gupta also telling me the meaning of EGM. Devika, good, very good. You are giving the answer. Extraordinary general meeting. Tejasvi Pawar, Devika, Pooja Gupta, Atul PS, Veni, Rahul Kanchan, Chandrasekhar sir, Gauri, tell me the meaning of extraordinary general meeting. What is the difference between an extraordinary general meeting and an annual general meeting? Give me the answer. Till then, I'm continuing. Okay. Now, how will the auditor be appointed in a government companies? Appoint auditor, central government, controller and auditor general of India. Who appoints? CAG appoints within 180 days of financial year start. Let's say the term of the auditor has been completed. Now, who will appoint the auditor? Controller and Auditor General of India will appoint the auditor within how many days? Within 180 days from the end of the financial year. If the company is newly incorporated, then the first auditor has to appoint within how many days? Within 60 days, we understood. Board, or else board will appoint within next 30 days, else shareholders will appoint within 60 days, which means what, people? In a government company, the controller and Auditor General of India will appoint the auditor within the first 60 days. If Controller Auditor General of India fails to appoint an auditor within first 60 days, the board of directors will appoint the auditor in the next 30 days. If the still board of directors fail to appoint the auditor in the next 30 days, shareholders will appoint the auditor within 60 days. Casual vacancy, CAG will fill the casual vacancy within 30 days, else board will fill the casual vacancy within 30 days. This we are talking about whom? Government companies. Now next, which companies are deemed to be government companies? 51% of paid up share capital is held by central, state, government companies or government corporation alone or together. Yes. Now, reappointment of a retiring auditor. When the reappointment happens automatically, don't wait till AGM. Perfect, Tejasvi Pawar. Tejasvi Pawar, you are absolutely correct. To deal with important matters, so company cannot wait till the next AGM. So company shareholders have to conduct extraordinary general meeting. Amazing, Tejasvi. Now, when does reappointment happens automatically? If auditor is not disqualified. Number 2, auditor is willingly. People tell me reappointment. I've just not told you. Just now I told you the auditor cannot be appointed after 5 years. He has to wait for 5 years cooling period. Then why is this reappointment of retiring auditor? People, this I'm talking about what? Small companies and OPCs. In small companies and OPC, auditor is not subject to cooling period. In that case, he can be reappointed when? If auditor is not disqualified by law. Number 2, auditor is willingly, he wants to do the audit. That means he is not refusing to do the audit in the company. And number 3, no special resolution that says that we do not want this auditor to be appointed. In that case, auditor can be reappointed. A retiring auditor can be reappointed. If no appointment happens even at the AGM, then the existing auditor continues. Atul PS, I saw your message. Extraordinary general meeting is special. That's okay, Atul. You are right. I'm assuming that you know the answer. Okay? All right. Now, what is the role of audit committee? If at all audit committee in a company exists, then every auditor appointment, including casual vacancy filling, must be based on their recommendation. So, do the board recommend auditor? No. Audit committee will recommend the auditor to the board. The board may accept, the board may reject. The board may reject, the audit committee has to give another recommendation. If still the board rejects that and the audit committee feels that no, this auditor is very good, then the board will have to compulsorily forward this recommendation to whom? To shareholders, so that shareholders can appoint that auditor at the annual general meeting, giving the reasons as to why he should not be appointed, and audit committee will tell to the shareholders why he should be appointed. And based on both the factors, shareholders will appoint the auditor. Next, what is a brutal summary of whatever we have learned? Big companies, mandatory rotation of auditor, cooling off period, no common partner firms. Audit committee plays a heavy role in checking, recommending, and reappointing of auditor. ADT 1 is a must. In this, like we understood, DR 12 has to be filed for appointment of a director. In the same way, ADT 1 has to be filed for appointment of an auditor. Resignation which means shareholders' approval is required when the auditor will resign. Government companies, CHE will appoint. Now let's talk about, come back over here again. Now people tell me, can you now answer the question? Explain the procedure for the appointment, rotation, reappointment of auditors. Section 139. Also discuss the role of audit committee in this process. Now can you answer the question? Accidentally click the button without completing the answer. No problem, Atul PS, no problem. That's absolutely okay. Now people tell me, now can you answer this question? Yes or no? Give me in comment section. Okay? All right. I am proceeding with the next topic, that is financial statements. People, I hope you all have got my notes, okay? It's very, very important. My notes is very, very important. This will only help you revise whatever you have studied in the most efficient way possible. Now, financial statements. What does financial statement include? Balance sheet, profit and loss account, income expenditure account for Section 8 companies, cash flow statement, statement of changes in equity, notes to accounts. This is what financial statements will include. Next, financial statement should give true and fair view. Must present a true and fair view of the company's state of affairs, and that should comply with two things: accounting standards and Schedule 3 format. What is the meaning of Schedule 3 format? Schedule 3 format is basically a format of balance sheet given in the Companies Act 2010 that should be followed by all the companies whenever they prepare the balance sheet. Companies cannot prepare balance sheet based on their whims and fancies. Company has to follow proper format whenever they are preparing balance sheet. All right. Now, exceptions. So if a company does not make a certain disclosures, when is that allowed? If that company is an insurance company, banking companies, electricity company, or others as notified under special law, if these regulators tell the company that it's okay if you do not disclose certain aspects of your financials, then that is absolutely allowed. It is not, we cannot say that the company is not following the true and fair view. Now, true and fair view overrides disclosure. Even if some disclosure are not mandated by law, true and fair view takes precedence. Yes. Annexure to financial statements. Notes to accounts are part of financial statement and must disclose all required information. Well, just 1 second. Yes, we are right. People, over here, we can say that even if some disclosure are not mandated by law, true and fair view is deemed. All right. Now, let's talk about annexure to financial statements. Notes to accounts are part of financial statement and must disclose all required information. Perfect. Now, laying at AGM, financial statement must be laid at the AGM. CFS requirement. What is the meaning of CFS? If Walmart is presenting its financials, Walmart should also present the financials of Flipkart. Okay. The company has subsidiaries, associates, JVs. Then they must also prepare CFS, present at AGM. Attached form AOC 1, which contains the details of subsidiary companies details and also comply with Schedule 3 and accounting standards. Now, when is a company not required to give consolidated financial statement? When will a company is not required to prepare consolidated financial statements? CFS is not required if company is a wholly owned subsidiary company. All members of the company give approval that it's okay if you do not prepare CFS. The company's securities are not listed. Parent company files CFS of the subsidiary company, which means what? Walmart prepares a subsidiary of Flipkart. Then Flipkart is not required to prepare the financials of Walmart also along with Flipkart. This is the answer. Next, CFS provisions, financial year 2014-15, not important. Deviation from the accounting standards, which means what? If financial statements deviate from the accounting standards, it must disclose what is the nature of deviation, what is the financial impact of the deviation, and what exactly was the deviation, what is the reasons for the deviation. All these three things should be mentioned. Central government exemption. Government can exempt specific companies in public interest. Okay. Penalty for contravention, imprisonment up to 1 year, fine 50K to 5 lakh or both. New provision, section 129A, government may prescribe classes of companies to prepare periodic financial results, get board approval and audit review, file within 30 days, which means what? Government can identify certain companies which are on the verge of doing fraud. Government is suspicious that this company will do fraud. For those companies, government can tell them that you have to prepare financial results periodically. Number 2, you have to take board approval and you have to do your audit review. And number 3, you have to file within 30 days. Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up, guys. Tejasvi Pawar, Atul PS, Devika, Pooja Gupta, Veni, Anuradha, Gauri, Abhinetra, Chandrasekhar Gopal sir, Atul PS, Rahul Kanchan. Guys, give me a quick thumbs up. Give me a quick thumbs up. Yes. Amazing. Absolutely a great, guys. Okay. Now let's talk about filing of financial statements. Filing of financial statements. Filing after annual general meeting within how many days? Within 30 days from the conclusion of annual general meeting, we have to file the financial statements along with prescribed fees. If the financial statements are not adopted in the AGM, then unadopted financial statements have to be filed within 30 days. That unadopted financial statements will be treated as provisional until adopted in the adjourned meeting, adjourned AGM, which means what? In the AGM, financial statement was not approved, so that AGM was adjourned to the next AGM. After that, until that period, the company has to file provisional financial statements, unadopted financial statements with the ROC. OPC filing, 1% company must file adopted financial statement within 180 days from the financial year end. Foreign subsidiaries, attach financials of foreign subsidiaries. Unaudited, if audit is not required by law, give explanation for any deviation. Same thing will apply to OPC also. If at all AGM is not held, file FS within 30 days from the last date, from the date on which AGM should have held. Penalties, 10K plus 100 rupees per day, maximum 2 lakh. Officers in default, 10,000 plus 100 rupees per day, maximum 50,000 rupees. Now, maintenance of books of accounts. Quickly, we'll complete this. Section 128 deals with maintenance of books of accounts. Maintenance of books of account at RO plus board approved location. Okay, now let's read it quickly. Companies must maintain books at the registered office or board approved location, reflecting a true and fair view on an accrual basis. Number 2, financial year end. The company has been incorporated in January 1. The financial year end will not be 31st March. It will be 31st March of next year. The government may allow a different financial year for a foreign subsidiary company, foreign company for the financial year of 31st December and Jan. Place of maintenance of books of account. Books should be maintained at RO. If not maintained at RO, they have to report to the ROC as to where exactly is the books of accounts maintained. Electronic books. Electronic means there should be accessibility of records, storage of records, backup should be there. Annual ROC reporting is required. Next, branch offices. Branch offices may maintain books of accounts locally. They have to send periodic summary to the registered office. And last, directors can inspect the books of accounts. Can he inspect at night 1 AM? No. He has to inspect the books of accounts during business hours. Period of maintenance, maintain books of accounts for 8 years. If under 8 years old, keep all the records since incorporation. If there is any investigation going on, the company has to maintain the books of accounts for more than 8 years. Responsibility and penalty. Who is responsible if these compliances are not followed? Director, CFO, and any appointed person like CS will be held responsible. Penalty will be 50K to 5 lakh fine. Now let's talk about eligibility, qualification, disqualification of auditors. Question will be asked in the exam. What are the eligibility criteria and disqualifications for appointment as an auditor under section 141 of the Companies Act 2013? Discuss with suitable examples. This question can come in an exam for 7 marks, people. You don't have to get scared, okay? Just have to understand this table. Eligibility, qualification, disqualification of auditors. Never ever be scared by looking at the question. First thing is, you should never be scared by just looking at the question. Just ask yourself one question. What is that one question, people? Tell me. What is that one question you should ask yourself the moment you see a lengthy, difficult answer? Till then, I'm continuing with the next topic. Okay, just give me your answer. Eligibility, qualification, and disqualification of auditors. Only a CA can become an auditor. Can a BCom graduate or MCom graduate be an auditor? No. In case of audit firms, majority of partners should be a CA. If majority of partners are CA, CS or CWA, they cannot be the auditor of the company. Majority of the partners should be a CA. Number 3, only CA partners can sign the reports on behalf of the firm. No other person can sign the audit report on behalf of the firm. Can a CA employee sign? Can you tell me, people, can a CA employee sign the audit report on behalf of the firm? Can a CA employee, not a partner, can a CA employee sign the audit report on behalf of the firm? Tell me the answer. Auditor is disqualified if the person or firm is a body corporate, but LLP is allowed. Number 2, they are an officer or employee of the company, not allowed. Number 3, they are a partner or employee of a officer or employee of the company, which means what? Company has got employees and officers. The person who is appointed to auditor is the officer or employee of this employer officer, not allowed. They or their relative hold securities more than equal to 1 lakh rupees in a company, they cannot be the auditor. If auditor has got loan and guarantee for more than 5 lakh rupees with the company, not allowed. Loan is 5 lakh, guarantee is 1 lakh. Now, they have a business relationship with the company which is not at arm's length price, not allowed. Their relative is a director or KMP in the company, which means what? Auditor's brother is a KMP or relative in a company. Atul PS, for which question did you say no? Atul, I totally forgot my question. Okay. They are employed elsewhere or full time, they cannot be the auditor of a company. They are auditor for more than 20 companies. But in the 20 companies limit, 1% company, small company, dormant company, private company whose paid up capital is less than 100 CR will not be counted. Tell me one thing, guys. Auditor is an auditor of 20 companies. In 5 companies, after 20 companies, in remaining 5 companies, he is auditor of a small company, he is auditor of OPC, he is auditor of a private company whose paid up share capital is less than 100 CR. Can he become the auditor of a company? Yes, yes, yes. Perfect, Atul. Next, they were convicted of fraud in the last 10 years. They provide prohibited financial services, prohibited services under section 144 to a company or its holding a subsidiary company. We're going to understand what are the prohibited services after this topic. So if auditor provides these services, he is completely disqualified by law. Let's again read it. Person, firm is a body corporate, not allowed. Number 2 is an officer or employee of the company, not allowed. If he is a relative or officer of the employee of the company, is not allowed. If he is the officer or employee of the officer or employee of the company, not allowed, not allowed. He or together with his relative hold securities more than 1 lakh in the company, not allowed. Auditor has given loans worth more than 5 lakh or guarantee worth rupees 1 lakh with the company, he cannot be the auditor. Next is they have got a business relationship with the company, but not at arm's length price, he cannot be the auditor. If it is at an arm's length price, it is allowed. Their relative is a director or KMP in the company, not allowed. They are employed elsewhere else. They are employed elsewhere, not allowed. They are auditor of more than 20 companies. They cannot be the auditor of a new company. They were convicted of fraud or in the last 10 years. Next is they provide prohibited services. Is everybody with me? Just give me a quick thumbs up, guys. Just give me a quick thumbs up. I'm going to ask you one very important question. I am the auditor of Indigo Airlines. Can I purchase flight tickets worth 5 lakh rupees. Sir, I only received director notes. Oh, Pooja Gupta will just tell the team to give you all the notes. Yes, guys. Guys, give me the answer for this question. Give me the answer for this question. If an auditor of an Indigo Airlines purchases flight tickets worth 5 lakh rupees, can he be appointed as auditor? Will he be disqualified by law? Pooja Gupta, I have told my team to give you the notes, okay? Don't worry. Yes, guys. Yes, yes, yes. Quickly answer me the question. All right. I'm moving on to the next topic. Till then, give me the answers, okay? All right. Vacation of office. If disqualified during tenure, office is vacated and a casual vacancy is created of the auditor. Very easy. Now, next. Reporting of fraud by auditors. If at all auditor finds out that there is fraud going on in a company, how is he going to report the fraud in a company? Let's understand. Number one, reporting process. If the auditor suspects fraud, they must report to the central government within how many days? Within 60 days, they have to follow these steps. Number one. Number one step is they have to report to the board of directors and audit committee. Plus, seek their response within how many days? Within 45 days, they have to seek the response. Number two, after they receive the response, they have to forward their report plus response plus board response plus auditor's comments to whom? To central government within how many days? Within 15 days. Number three, if no response within 45 days, the auditor has to anyway submit the report to the central government. Now, they also have to submit the report to whom? Ministry of Corporate Affairs. Or the report should be in a letterhead. And last is filing form 81 has to be done. Yes, Pooja Gupta, Atul PS, perfect, perfect, guys. You guys are absolutely right. Now, next, protection of auditors. Auditors are protected from liability when reporting fraud in good faith, which means what? If the auditor has not discovered any fraud, but still he has reported in good faith, then that company cannot remove the auditor. Auditor will include cost accountants and company secretaries also in this case. Easy, people. Now let's talk about prohibited services for auditors. Question will be asked in the exam. List and explain the services prohibited to be rendered by auditors under section 144 of the Companies Act 2013. What is the meaning of directly or indirectly in this context? Let's quickly understand what is written in this chapter, what is written in this topic. Then we will complete this within next 15 minutes. Then we'll start with the new chapter, that is board meeting minutes and registers. Very small chapter, people. Quickly we'll finish it off. All right. Yes. So auditors are prohibited from providing the following services. What are the services? Number one, accounting, bookkeeping, internal audit, financial information system, actuarial services, investment advisory services, investment banking services, outsourced financial services, management services, any other services prescribed by law. What this directly, indirectly means, what cannot be done directly can also be not done indirectly. What can't be done directly, that also cannot be done indirectly is the meaning. Individual auditors cannot provide these services through relatives or associated entities. Audit firms cannot provide these services through partners or parent entities or subsidiary companies. Is everybody with me? Just give me a quick thumbs up. Can an auditor provide tax audit services. Tell me people, can an auditor provide tax audit services? People, tell me, can an auditor provide tax audit services to a company? Will that tax audit services covered in this? Give me answer. Tell me the question and then give me the answer. Okay, otherwise I forget what question I asked. All right. Next, companies auditors rule. Companies auditors report order Caro rules 2020. Without wasting any time, let's understand what should be reported in the Caro report. Yes, Caro report is effective from financial year 2020 to 2021 onwards. Applies to all the statutory audits under Companies Act except those specifically exempted. Now, which companies are specifically exempted? All the companies for whom stat audit is compulsory, they have to also provide a Caro report. Caro report basically tells more than Caro report basically requires to report on 21 categories of transactions. They're going to understand about that in detail. So, which companies are not allowed, not applicable? Banking companies, insurance companies, Section 8 companies, one-person company, small company, certain private company. Now, which are the certain private company? Paid up capital reserves is less than 1 year, borrowing is less than 1 year. For those companies, Caro report is not applicable. People, is everybody with me? Give me a quick thumbs up. Is everybody with me? Give me a quick thumbs up. Pooja Gupta, Atul PS, Devika, Tejasvi Pawar, Veni. Devika, Tejasvi Pawar, Veni, Pooja Gupta, Atul PS, Gauri. Where is Gauri? Rahul Kanchan, where is Rahul Kanchan? Abhinitra, Chandrasekharan Gopal sir. Where are you guys? Give me a quick, sweet thumbs up. Now let's understand the key reporting requirements. And then last topic, then we will be done. Yes, Pooja Gupta. Perfect. Now, what are the key reporting requirements? Quickly, let's understand. Records, physical verification, title deeds, revaluation, Benami holdings, which means what? Land which is shown in the company's books of account does not actually belong to the company. In that case, auditor in its Caro report has to report that this land does not belong to the company. Number 2, inventory, physical verification, which means what, people? Stock mismatch found at the year end should be reported by the auditor in its Caro report. Working capital loan, which means what? I have taken working capital loan. I have taken a loan of 10 CR, but the working capital stock I have also got only 5 CR. With 5 CR stock, I have taken a loan of 10 CR. There is a major mismatch which should not be allowed. It should be immediately reported by the auditor. So, physical verification, major discrepancies, if it is more than 10%, it should be reported immediately. Devika, Chandrasekhar Gopal sir, Gauri, Tejasvi Pawar, Pooja Gupta. Guys, interact guys, give me the answer. If you give me the answer, I will ask you more questions. You will get more. You will get, what do we say? You will have more fun, guys. Okay? Just give me the answer. You will have more fun. Trust me. All right. Loans and advances, terms overdue, steps for recovery. Company gave interest-free loan to whom? A group company. It should be immediately reported in the Caro report. Loan to directors or entities in which directors are interested. 2 crores loan was given to directors firm. Must check if it was allowed under the act. If it is not allowed, they have to report it in the Caro report. Whether deposits follow RBI and Companies Act rules. FD taken without filing DPD3. DPD3 is filed for whenever company receives any deposits. Company has received deposits, but it was not filed immediately. Auditor has to report this. Whether maintained and prescribed under rules. Cost records, whether it is maintained and prescribed as per the rules. Cost records for manufacturing unit. Next, whether GST, TDS, Provident Fund, ESI has been paid or not. If not, reporting delay, that is more than delay, if it is more than 6 months, it has to be reported immediately. TDS if not paid for 6 months, it has to be reported. Next, whether unrecorded transactions disclosed in the tax, which means what company has earned, company has got black money and which is not reported in the tax filings, it should be immediately disclosed in the Caro report. Unrecorded income, loan default, default in repayment of borrowing or loans must be immediately reported. IPO, FPO, end use of IPO, FPO, which means what, I have raised money from the public and then I'm buying luxury Ferrari, I'm buying luxury BMWs, which is not allowed. Immediately auditor has to report this into Caro report. Next, fraud reporting. Any fraud by or on the company should be reported. Nidhi company compliance. Net owned funds should be more than 20% in a Nidhi company. If it is not compliant, they have to report. Auditor has to report. No overdue. RPD transactions, internal audit, non-cash deals with directors. Land has been transferred to directors without shareholders' approval. It has to be reported by in the Caro report. Next, RBI registration, cash losses, resignation of auditor, going concern, whether the company can meet liabilities within 1 year. Who will report? Auditor has to report in the Caro report. Next, CSR compliance, consolidated financials. And that's it. All these things should be reported in the Caro report. Is everybody with me? Give me a quick thumbs up. Yes. Now, let's talk about removal, resignation of auditor and special notice. Guys, after this, we will take a break of 5 minutes and then quickly we'll complete the chapter within next chapter within half an hour. Okay, the next chapter is super small. Okay, trust me. All right. Removal of auditor before expiry of term. Approval required if okay. Whose approval is required, people? Central government's approval is required before removal. They have to file form. Which form? E-form ADD2. Next, board action. Board must apply for approval within 30 days of decision. Shareholder resolution. Once central government approves, they have to hold a general meeting within 60 days to pass a special resolution. And right to be heard. I have already told you, auditor must be given an opportunity to be heard before he is removed by the company. All right. Now, resignation of auditor. Now that we have understood, removal of auditor. Approval is required, board action is required, shareholders resolution is required, and a right to be heard is done. Next, resignation of auditor. You have to file which form? ADD3. Within how many days? Within 30 days of resignation. Government companies, if it's a government company, file ADD3 with Controller and Auditor General of India 2. Penalty, if not followed, 50,000 rupees or audit fees, whichever is lower, plus 500 rupees per day if delay, maximum 2 lakh rupees. Penalty will never be asked in the exam, people. Don't worry. Now, special notice, and then we are done with the chapter. Special notice. When is special notice required? Removal before 5 or 10 years complete, which means what? You have removed the auditor before his term is completed. Needed special resolution. Special notice required if removing auditor before completing 5 years or 10 years. New appointment is in place of meeting. Required to appoint new auditor in place of retiring auditor at the AGM. Next is circulation of auditor's representation. If auditor sends a representation response, company must circulate it to all members and file it with the ROC if not circulated. Now, what is the purpose of this? Let's understand quickly. All right, people, let's revise this once again. We know that if the auditor is removed before his term is completed, special notice is required. So, if new appointment is in place of the meeting, required to appoint new auditor in place of retiring auditor at the AGM, then also special notice is required to ensure members and auditors are notified. Next, if auditor sends a representation in response, a company must circulate to all the members or file it with the registrar if not circulated. What is the purpose of this? To protect auditor's right to be heard publicly, which means what? Even if the auditor is not coming to the AGM publicly, he can send his written representation that XYZ things happen. Because of the XYZ things, I have resigned in the company. All right. Next, why special notice matters? Protects the independence of the auditor, prevents abrupt or unbiased removal, allows shareholders to make informed decisions based on the auditor's version, ensures compliance with the due process. With this, we are done with the chapter of accounts and audit people. People, one more topic is remaining. Quickly, we'll complete this off. Okay, CSR. So, which company is supposed to appoint a CSR committee? Very, very important, people. Very, very important. Which company is required to appoint CSR committee? Number one, net worth is more than 500 CR or more. Number two, turnover is more than 1000 CR or more. Or net profit is more than 5 CR or more. Have to appoint a have to form a CSR committee. Now, CSR committee composition minimum 3 directors are required, including at least one should be independent director. If there is no independent director, 2 or more directors may form the committee. Board must disclose CSR committee where? In the board report. Next, what are the responsibility of CSR committees? They have to formulate and recommend CSR policy based on Schedule 7. Schedule 7 based on activities where the company can spend their CSR amount. Number 2, recommend CSR expenditure to whom? Board of directors. In the same way, audit committee recommends auditor appointment to the board of directors. In the same way, CSR committee recommends CSR expenditure to board of directors. Number 3, monitoring implementation, whether board of directors are properly following the whether properly they are incurring expenditure or not, will be implemented by whom, will be monitored by whom? CSR committee. What are the responsibilities of board? Approving CSR policy that was recommended by the CSR committee. Number 2, disclosure of CSR policy in reports and websites. And number 3, ensuring 2% of average net profit in the last 3 preceding financial years are spent on CSR. Now, where can we spend CSR? Can we, if I'm in Pune, can I spend this CSR amount in Pune, or can I spend in Chennai? CSR has to be given preference, should be local areas of operation should be given preference. If CSR money is not spent within, if we have not spent, then within 30 days from the closure of financial year, they have to transfer that amount to unspent CSR amount. Within 3 years, then if the money is not spent within 3 years on CSR expenditure, then within 6 months, company will have to transfer that amount to whom? Central government fund like PM CARES. Now, CSR accounting disclosure, they have to follow. When we understood how should the remuneration be calculated of our directors, net profit 5%, 11%, the remuneration limit we understood using section 198. Same section will be coming over here, section 198, for average net profit calculation, adhering to ICI guidelines note. And then we are done with the chapter of accounts and audit. Is everybody with me? Give me a quick thumbs up. Is everybody with me? Now we're going to solve 3 MCQs from this chapter. Okay, give me a quick thumbs up. Guys, give me a quick thumbs up. Yes, sir. Great, Pooja Gupta. Now, guys, tell me the answer of first question. The first auditor of a company other than government company must be appointed by whom? Shareholders at AGM, board of directors within 30 days of incorporation, audit committee, or ROC. What is the answer of this? What is the answer of first Question. The first auditor of a company must be appointed by whom? Shareholders at AGM, board of directors within 30 days of incorporation, audit committee, or ROC. First answer is B. Tejasvi Pawar is saying answer is B. Okay. Answer is B. Gopal sir is also saying answer is B. Answer is B. Perfect, guys. Perfect, perfect, perfect. Pooja Gupta, Veni, perfect, guys. Now, next question is very easy. Now, I will not ask that. Yes. What is the answer of this? Form 881 must be filed with ROC within Devika 1B, Veni 1B, Pooja Gupta 1B. Amazing, guys. Amazing. You guys are absolutely right. Now, I'm going to focus on only difficult questions. Four answer is A. Within 15 days of AGM, Tejasvi Pawar is saying within 15 days of AGM, ADT1 must be filed with the ROC. Any other answer, guys? The answer is A. Perfect. Perfect, Tejasvi Pawar. Perfect. Yes. In case of disagreement between the board and audit committee on auditor appointment, the board decision prevails, the audit committee's decision is final, the matter is referred to shareholders, and last is ROC decides. What is the answer of this? Where is Vijay? Vijay, are you there? Vijay, Pooja Gupta, Devika, Veni, Gopal sir, Atul PS. Tejasvi Pawar is saying answer is B. All right. Tejasvi Pawar answer is C. The matter is referred to shareholders. Tejasvi Pawar, I told you, audit committee will recommend to the board. Now, board will reject or board will accept. In case the board will reject and audit committee says, no, you have to appoint this auditor, the recommendation is final. Then the board auditors do not have any option but to tell this to shareholders about that audit committee has. It is the duty of board auditors to send the recommendation of the audit committee to the AGM, whether they like it or not. Pooja Gupta? No, 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 guys. No, no, no. Now, did you understand? Answer? Yes. This is a trick question. Yes. Which is not a part of financial statement under section 129. Which is not part of financial statements under section 129. No, Devika. No, no, no. Answer is wrong. Tell me which is not a part of financial statements under section 129. Six answer is C. Director's report. Perfect. Perfect, TSC. Perfect. Now this is a tricky question. CFS. Perfect, Pooja. Devika. Perfect. Great, guys. Great. Gopal sir, amazing. CFS are mandatory for companies with what? Four options. A, B, C, D. A, subsidiary, turnover is more than 100 CR, listed companies, or all of the above. What is the answer? Tejasvi Pawar is saying answer is 7D. All of the above? No Tejasvi. Answer is subsidiary company. Any company which has got subsidiary company has to prepare CFS. Okay, people, that means you have to solve all the MCQs of accounts and audit. Okay, do not ever skip this chapter. Okay, questions can be asked in the exam. You can easily get 30 out of 30 marks in corporate economic laws. Only 10 marks, even if you write answers, you will easily pass. But our goal is to score an exemption. Okay, our goal is to score an exemption. Atul PS, answer is Atul, tell me, if I am a listed company but I do not have a subsidiary company, do I have to prepare CFS? No. Yes. Now, deviation from the accounting, it's easy, people. Nothing exciting over here. Yes. Exemption from preparing CFS apply if the company is a wholly owned subsidiary company, securities are listed abroad, both A and B, none of the above. What is the answer of ninth question? What is the answer of ninth question? Exemption from preparing CFS apply if the company is WOS, securities are listed abroad, both A and B, none of the above. What is the answer of this, guys? Tell me quickly. Perfect, Atul, perfect. What is the answer of ninth question? Ninth answer is C. Perfect, perfect. Tejasvi Pawar, perfect. Well, see, I have given you so many MCQs. These are number of MCQs you have to solve before exams. Understood? Now tell me the answer of 35th. Physical verification of inventory must be conducted. Pooja Gupta, amazing. Tejasvi Pawar, amazing. Yeah. Physical verification of inventory must be conducted A, B, C, or D. Quarterly, annually, at reasonable intervals, or biannually. Devika, amazing, amazing, Devika. Devika, I will tell my team to share it, okay? Yes. Chandrasekhar and Gopal sir are saying answer is B. Answer is, guys, answer is C. At reasonable intervals. Physical verification inventory must be conducted at reasonable intervals. All right. Last. Yes. Tell me the answer of this. Unspent CSRF funds must be transferred to a designated funds within how many days? 30 days of financial year end, 6 months of AGM, 3 years of allocation, 1 year of allocation. What is the answer of 37th question? Answer is B. It is 30 days from the financial year end. Guys, I will tell you again. From 30 days, you transfer the fund to unspent CSR account. Then, if still you did not spend within 3 years, then you have to transfer to a government fund like PM cares. Understood, guys? Understood? Yes, Devika, perfect, perfect, perfect. Now, let's take break of 5 minutes. And people, do you want to have dinner? Just take 10 minutes break and then we will meet after that. Within 20 or 30 minutes, we'll complete the next chapter, okay? Do you want to take a break? Tell me. If you're hungry, go have your dinner, people. It's absolutely okay. I will wait. Tejasvi Pawar is saying, no, sir. Why, Tejasvi? Are you not hungry? Or is your dinner over? All right, Tejasvi Pawar. Remaining guys, Devika, Gopal sir, Pooja Gupta. What do you think? Should we take a break of 5 to 10 minutes or what? Atul PS, tell me, bro. Atul PS, Gauri, where is Gauri? Veni, Pooja Gupta, Vijay, where is Vijay? Burma, Abhinetra is also not there today. Pooja Gupta says no break. Okay, Pooja Gupta, what we will do is let's take a break of 5 minutes. Yes. Uh, Devika, Pooja Gupta, let's take a break of 5 minutes, okay? We will meet in 5 minutes. Hey Siri, 5 minutes timer.
5 minutes starting now.
Cool, guys. I will see you at 9:13. Yes. Okay. Yes, people. Hi, everybody. Hi, everybody. Hi, everybody. Yes, yes, yes. Is everybody with me? Give me a quick thumbs up. Let's start next chapter and complete it in the quickest and the most beautiful way possible. Are you guys with me, guys? Yes, yes, yes. Is everybody with me? Everybody with me? Give me a quick thumbs up. Give me a quick thumbs up. All right. Tejashi Pawar. So let's begin the next chapter, that is board meetings, minutes and registers. Very easy chapter. Nothing rocket science in this, no limits, nothing. All right. Yes, Veni, welcome back. Atul PS, Tejashi Pawar, Devika, where are you? Chandrasekhar Gopal sir, Pooja Gupta, come back, quick. All right. Next is 174 talks about quorum for board meetings. Always remember, what is the meaning of quorum? People tell me in the comment section. What is the meaning of quorum? What is the meaning of quorum? Quickly tell me. Till then, I'm going to tell you the provisions of quorum. Quorum for board meetings. If there is no quorum, meeting is invalid. Quorum requires 1/3 of total directors or 2, whichever is higher, should be the minimum quorum required for a board meeting. Board meeting can be done by audio or video conferencing. It can also be counted. Next, the quorum falls below the required number. Board directors cannot do any business decisions until, okay, if quorum falls below the limit, then board directors can still meet, but they cannot do any business transaction, but they have to meet to decide what? To appoint new directors or to call a general meeting. Apart from these two purposes, board directors cannot function at all. Minimum person to attend the meeting. Veni, absolutely right, Vini. Perfect. Now, special provisions. For Section 8 company, minimum quorum is 8 or 25% of the total strength, whichever is lower. But lower should have minimum number of 2 directors. Devika, absolutely amazing. For OPC company, there is no quorum required because there is only one member. Fractional, if the quorum is 1/3 is calculated as 2.5, then 2.5 will be calculated as 3. All right. Perfect. Now, what does secretarial standards talk about quorum? They say that quorum should be present throughout the meeting, which means what? If 3 directors are there, 2 directors left the meeting, and by the end of the meeting, the 2 directors returned to the meeting. Not allowed. Quorum should be present not on the day, on the start and end date, but should be present throughout the meeting. Number 2, for committee meetings, all members are required otherwise unless specified in the articles of association. Next, a director. One second, people. All right. If directors are interested, if 2/3 or more directors are interested, quorum is made by whom? Non-interested director. Which means what? If there is a transaction that is to be done by my brother, with my brother, I am the director, I should not be present in the meeting. If 2/3 of the more or 2/3 or more directors are interested, quorum is made by whom? Non-interested directors. And non-interested directors should be minimum. How many? Minimum 2 non-interested directors should be compulsory be there. A director with personal interest in a contract arrangement being should be discussed is called as interested director. Okay, let's not talk about this. Is very easy. Basically, what is it saying? If the director is interested and if there is a contract in arrangement. Hi Siddesh. Hi Maidili. Hi, Maidili. How are you? Where are you from? Yes. Next, special provisions. Okay, this is done, people. All right. Next, let's talk about section 173, meeting of board of directors. Meeting of board of directors. What should be the frequency of meeting of board of directors? First meeting should be held when? Within 30 days of incorporation. But after that, minimum, how many meetings have to be conducted? Minimum 4 meetings have to be conducted. But the gap between two meetings should not exceed how many days? 120 days. But exception is for OPC, small company, dormant company. This rule is not applicable. But they will have to meet. Small companies, OPCs, and dormant companies will have to meet at a board meeting. When? At least once in every half year. But the gap between two board meetings should not be people. Gap should not be less than 90 days. Should not be less than 90 days. People, you will get confused over here, okay? Half year, meeting 1, meeting 2. Gap should be minimum 90 days. Understood, people? Understood? Is everybody with me? Over here you may get confused, and over here you may get confused. 120 days and over here 90 days. Is everybody with me? Give me a quick thumbs up. Maidili, where are you from? Tell me, beta. Next, participation in the board meetings. Board meeting can be done by audio visual means. And number 2, they will have to record plus recognize directors' participation in the board meeting. They have to store meeting details where date, time, and content is properly recorded and stored. Video conference requirement, very easy. Uninterrupted connection plus chairperson plus company secretary have to maintain the integrity of the board meeting. Plus, it should be properly secured. Number 2, proper equipment should be there. Number 3, recording and storing proceedings. Number 4, verifying participation identity. And last is ensuring clear communication is there in the video conferencing of board meetings. Exception is, let's say I am a disabled person, I require an assistant. Then this rule will not be implied saying that this assistant cannot participate in the board meeting. I require the assistant because I am disabled. In that case, assistant attending the board meeting is completely allowed. All right. Now, next, committee meetings. Committee meetings, members should meet as per the requirements. Independent directors must meet at least once in a financial year. All right. Notice of the board meeting. Notice must be given. At least 7 days notice must be given to board of directors for attending the board meeting. The notice can be sent via hand delivery, via post, via electronic means. Shorter notice. Can a notice be called at a shorter notice? Shorter notice means, if can I send a notice to board directors to attend the meeting tomorrow? Yes, it is possible. But at least one independent director must attend the meeting. If there is no independent director is present, resolution must be circulated by and ratified by at least one independent director. Which means what? If there is no independent director present tomorrow in the board meeting, whatever decision has been taken in the board meeting, it should be approved and consented by a independent. That is called as ratification of decisions of the board. Next, what are the additional requirements? Notice must also mention the option of electronic participation. Directors must notify if attending electronically. Number 3, a director may declare a preference for electronic participation at the start of the year. That I will be attending board meetings I will be attending all the board meetings through video conferencing only. Is everybody with me? Give me a quick, sweet, lovely thumbs up. Guys, is everybody with me? We are going to complete this chapter in the next 20 minutes. That's it, people. That's it. Today we are not going to extend like how we did yesterday and day before yesterday. Now that you have understood my pace, I'm going to speed up a little bit. All right, all right, all right. Give me a quick thumbs up, guys. Give me a quick thumbs up. Perfect. Veni, Tesi Power, Maithili, where are you from, beta? Atul PS, yes sir. Perfect, perfect, perfect. Next is Secretariat Standards 1 says that notice must follow a director's preferred mode of delivery. That director saying that I want to receive notice via email because I keep on traveling. Do not send me hand delivery notice. Then that director should be sent notice via email only. Perfect. Pooja Gupta, Chandrasekhar Gopal sir, Devika, Atul PS, Maithili. Amazing, amazing, amazing. Notice must include meeting serial number. Means what? 2024 meeting number, date and time. Date, time, venue, details of electronic participation. Who is participating electronically and from where is he participating? Every detail should be mentioned in the notice, which saying that notice calling the board meeting. Next, agenda and notes to agenda must be included. Agenda means what? Today we're going to talk about X, Y, Z business activities. 1, 2, 3 activities. This is called as agenda. Notes agenda means what? More detailed agenda about 1, more detailed agenda about 2, more detailed agenda about 3. This is called as notes to agenda. Proof of delivery must be maintained. Saying that speed post receipt should be mentioned, should be maintained by the company. Should be maintained by the company. People, I will tell you one case. I will tell you one interesting case. Maithili Tamil Nadu ninga. Okay, okay. Tamil pesa theriyuma illa ninglo North Indian na Tamil Nadula. Yes, guys. People, do you know who was Cyrus Mistry? Do you know who was Cyrus Mistry? Do you know anything about him? Cyrus Mistry, Tata Son, Cyrus Mistry, board conflict. Do you know him? Tell me in the comment section. Till then, I am starting with the next topic. Meetings cannot be scheduled on national holidays. 26th January, 15th August. On these national holidays, meeting cannot be scheduled. Board meeting. Now next, minutes of the meeting. Under section 118, Companies Act, company must record minutes for general meeting, for shareholders or creditor meeting. Number 3, resolution passed by postal ballot. Number 4, board meetings. Number 5, committee meetings. Yes, that's it. These types of meetings and records must be maintained by the company. Next, key requirements. Meetings must be recorded and signed within 30 days of meeting, which means what? Today. Okay, Atul, no problem. I'm going to tell you one interesting case which will grab your attention towards this chapter. So, today my meeting is done. Within 30 days, that meeting must be signed by the chairperson. Okay? It should not be kept unsigned. After you have conducted the meeting, it should be signed by the chairperson. Accuracy, minutes must summarize what? Proceedings accurately. It should not contain unnecessary details like he came, he drank water. Those unnecessary details should not be mentioned. What all transaction happened in the company, it should be mentioned in a summarized manner. Number 3, appointments. All appointments made during the meeting must be recorded. Appointment of directors, appointment of KMP, appointment of CA, auditor, CMA, all the details of the appointment must be recorded. Chairperson discretion. Chairperson may include or exclude matters from the minutes. If something wrong or ugly is going on in the meeting, chairperson will say that these things should not be included in the minutes of the meeting. Legal evidence. People, once meeting minutes have been recorded, it serves as a legal proof of the company's proceedings. No free circulation. Minutes cannot be circulated at the company's expense. Compliance with standards. The company must follow SS 1 and 2. SS 1 talks about how should the board meeting be conducted. SS 2 talks about how should the general meeting be conducted. Now I will tell you one case study. One amazing case. Tata Sons was the Tata Group chairman who had a yes, Devika, perfect. So people, Cyrus Mistry was the chairman of Tata Sons. He was removed from the chairperson and he should be attending the board meeting. So he was not even given the notice of the board meeting. All the remaining directors met secretly. They passed a resolution that we need to remove Cyrus Mistry from the board of directors, and then they removed Cyrus Mistry without even informing Cyrus Mistry that he has been removed. When he came to the office, he was told that you are no longer the chairperson of Tata Sons. How would you feel, people? You are the chairperson of one of the top Indian companies, and suddenly tomorrow you have been removed, and you do not even know when did it happen, and how did it happen. The same thing happened in the Cyrus Mistry case, and when the court asked the board of directors, they did not record these things in the minutes of the meeting. They told that we did not record the minutes of the meeting. The minutes have been destroyed or been altered, or it is not available with us, which is very, very wrong, people. So that's the reason why these things we are studying these things, so that no person can remove unnecessarily from the board of directors. But in the end, Tata Group, only one Cyrus Mistry was removed from the company. But let's not talk about the end case. Let's understand for what reasons are we studying this law. Okay, so that no person should be removed unnecessarily in the meeting. Nothing unusual should happen in the company without the knowledge of all the board directors. For that reason, we are studying this law. All right, people. Yes, passing of resolution by circulation. People, there may be some situations where meeting of board of directors physically is not at all possible. So in that case, what happens is board meeting resolution is passed by circulation. What is meant by circulation means what? All the directors will receive a notice saying that the company is going to take XYZ decision. Do you consent or do you disagree with this? Do you say yes? Do you say no? Do you say yes? Do you say no? Like this, all the directors will receive the notice. Now, conditions for passing a resolution by circulation. The draft resolution and okay. Now we're going to understand using mind map. Requirements. Draft resolution plus required documents should be sent to all the directors and or all the committee members. If it's an audit committee or nomination remuneration committee, if it's a committee meeting, it should be sent to all the members of the committee. If it is not a committee meeting, it should be sent to all the members of the board at their registered address by hand delivery, or P stands for, once again, yes, post, courier or email. Yes, post, courier or email. Number 2, resolution. People, once again, this is a little confusing. The resolution is passed if a majority of directors or members approve it. Which means what? If majority of directors, we are going to understand over here. So requirements is basically, people, draft resolution plus required documents will be sent to all the directors or all the committee members at their registered address by hand delivery or post or courier or electronic email. Next is resolution is said to be passed if all the majority directors or members approve it. Now we're going to understand, if in urgent cases, if 1/3 of the directors say that no, we want to attend a physical meeting, you cannot hold this important matter in such an by resolution by circulation. In that case, chairperson has to arrange a board meeting physically. People, tell me, when should a chairperson arrange a board physical meeting? Tell me. When should a chairperson arrange a board meeting, whether physical or video conference? Anything is okay. Tell me, when should a chairperson arrange a board meeting? Next, received resolution. Resolution by circulation recorded in the minutes of the next board meeting or committee meeting. Which means what? Any resolution which is passed by resolution by circulation has to be recorded in the minutes of the next board meeting. Now last, SS1. Directors have time, maximum 7 days to respond to resolution by circulation. Board of directors have got maximum how many days? 7 days to respond to resolution by circulation. Yes. Now, what are the items that cannot be passed by circulation, which means what? These matters are so important, which requires discussion. This cannot be just approved or disapproved by ballot paper. These matters requires discussion. These matters requires actual board meeting. What are those matters? Number one, general matter. There are 4 items: noting minutes of audit and committee meetings. Number 2, approval of financial statements and board report. Number 3, compliance certificate for legal compliance. Number 4, appointment of secretarial and internal auditors. Specific items: borrowing money other than by issuing debentures. Number 2, investing company funds. Number 3, granting loans, guarantees or securities. Number 4, making political contribution. Number 5, approving remuneration of MD, hold and manager. Number 6, removal or appointment of KMP. Number 7, appointment of MD or manager in multiple companies. Number 7, appointment of a director in a casual vacancy, which requires approval in the next general meeting. And number 8, sanctioning RPT, not in ordinary course of business, but it is at arm's length price, sale of subsidiaries, purchase or sale of material assets outside normal business. And then last is approving directors' payment for loss of office. People, can you tell me the meaning of approving directors' payment for loss of office in the comment section quickly? Is everybody with me? Give me a quick thumbs up. Is everybody with me? Give me a quick, sweet, short thumbs up. All right. Corporate actions: authorization of securities buyback, issuing securities or debentures, approval of mergers, acquisition or reconstruction. And number 4, business diversification, acquiring substantial stakes in other companies. For listed companies, all these matters. What are the matters? Approval of annual operating and capital budgets. Number 2, informing on KMP remuneration. Number 3, material legal actions, show cause, demand, penalties, notices, environmental safety concerns, material financial defaults, JV or collaboration agreements, transaction involving IP or goodwill, significant labor or HR developments, foreign exchange risk management, non-compliance with regulatory or listing requirements. People, I would want you to just read this, okay? Do not learn this because it is not possible. Just read it and try to learn 7 points. Try to learn 7 points, because if at all question is asked in exam, you should not go blank. Okay? I'll tell you what all things you have to learn. These 4 are very important, people. General items: noting minutes, approval of financial statements, compliance certificates, appointment of S and internal auditors. Specific items: borrowing money, investing company funds, granting loans, guarantees or securities. Okay. 1 and 2 are opposite. Investing company funds, also making political contribution, approving remuneration of whom? MD, holder, manager, and appointment or removal of KMP. These are related. These are related. Appointment of manager or director in multiple companies. Appointment of, only these things you have to learn, people. Okay, appointing of director in casual vacancy. Now next. Now, if at all you remember, you are try to remember this. These talks about RPT or significant transactions, purchase sale of material assets, approving directors payment. Okay, this is a very different thing. So these 3 are significant accounting transactions. Just try to learn these things and then you are done. All right, people, do not try to learn everything because it is not possible. But I would expect you to at least read everything before you go to the exam. At least read everything, because question will be asked in exam. Given a situation, you have to tell whether this can be passed by resolution by circulation or not? You should be able to answer that. Okay, basically, or if the matter is very important to you, if you think that matter should be discussed in the board meeting, then can simply write this matter will require board meeting discussion. Board meeting, this matter require conducting of board meeting, whether physical or video conferencing, both are all right. Now corporate action is basically, people, very easy. Corporate action, buyback, this is IPO, this talks about IPO, mergers, business diversification, acquiring, which means what? Over here we understood acquiring, buyback, merger and IPO is included. Next, for listed company, transaction involving IP or goodwill, foreign exchange risk management, non-compliance with regulatory listing obligations, information on KMP remuneration, material financial defaults, JV. These things you have to learn it, people. Whatever I'm trying to tell you, just learn it, okay? Yes, these are very easy to learn topics. All right, perfect. Now with this, let's move on to the powers of the board. What all powers do board of directors have? Board of directors are authorized, can access all powers of the company is authorized to, but must comply with Companies Act, MOA, AOA, any regulation passed in general meeting. Which means what? Board of directors have all the power that is given in the Companies Act 2013, plus MOA and AOA tells them. And number 3, if shareholders have put any restrictions on the board of directors, the board of directors have to follow that restriction. They cannot say that in Companies Act 2013 we have the power to do XYZ things. No. First things first, board of directors cannot exceed shareholders' power. Understood? Is everybody with me? Give me a quick thumbs up. The board cannot exercise powers meant to be decided by the company in a general meeting through past decisions. Those past decisions are valid. What is the meaning of this, people? Let's understand the meaning of this. Meaning of this is, in 2020 to 2024, board of directors had 10 powers. Let's say 10 powers. On 2024, shareholders have told that board of directors cannot have so many powers. We'll only give them 5 powers. But that does not mean that the 5 powers that were taken in the past from 2020 to 2024, they are invalid. No, they are valid. But from 2024, whatever actions will be taken by the board of directors should be followed by the restrictions given by the shareholders. Is everybody with me? Give me a quick thumbs up. Only Veni is there. Maidili, Devika, Chandrasekhar Gopal, Ingarikil Ningala, Pooja Gupta, where are you? Atul PS, are you there? Yes. Next, powers that require board resolution, which means what, people? Certain certain transactions, certain decisions in a company will obviously require board resolution. Calls for unpaid shareholder amounts, authorizing buyback, issuing securities, borrowing money, investing funds, granting loans or security for loans, approving financial statements, diversifying business, approving mergers, amalgamation, acquiring a controlling stake, and last is other prescribed matters will require board resolution. Means what, people? Not every decision will be taken by the board of directors. Small decisions, like say paying for operating expenses, these decisions cannot be taken by board of directors. It can be outsourced to a person, but certain decisions has to be taken by a board of directors, and certain decisions has to be only taken by whom? Shareholders only. All right. Additional powers requiring resolution, making political contribution will require board BR, appointing KMP will require BR, appointing internal secretary auditors will require BR. Delegation of powers, BR can delegate powers to committee of directors. Let's say board, let's say CSR policy is outsourced to whom? CSR committee. In the same way, appointment of auditor, this work is outsourced to whom? Audit committee. MD or principal officer, principal officers or branch office, which means what? Board can delegate the powers to three people: committee of directors, managing director or principal officer, and number three, principal officer or branch offices. Perfect. For section 8 company, these decisions can be made through circulation. Yes, which means what? The section 8 company is a people section 8 company, we need to understand the section 8 company do not have lots of funds. Okay, so if conducting board meeting will require incurring certain expenditure, section 8 company can choose to conduct all the meetings via circulation, resolution by circulation. This is the logic behind why section 8 company are exempt from conducting board meetings. Understood? Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up, guys. Is everybody with me? Maithili, Chandrasekhar Gopal sir, Tejasvi Pawar, Atul PS, Devika. Did you guys have your dinner? Okay. Shareholders role. Shareholders can impose restrictions on board powers, which means what? Just now we studied board of directors and KMP. In that we understood in section 180 that says that not all decisions can be taken by board or directors. Certain decisions can only be taken by shareholders. Teji Pawar, no sir. Atul, yes sir, yes sir. Oh. Teji Pawar, within 15 minutes max, we will complete this chapter. Okay, just give me 15 minutes. Now restrictions on board, powers of board. Selling, leasing, disposing of assets which is more than 20% of total assets. Array. Yes. Selling, leasing, disposing of assets which is more than 20% of total assets. This will require shareholders approval. Number two, people, this we understood in the KMP chapter also. Okay. In investment compensation from merger amalgamation cannot be done by trust or securities without whom? Shareholders approval. Number three, borrowing more than paid up share capital plus free reserves plus securities premium plus, and then last, remitting or extending repayment owed by director. Key compliance is you have to file MGT 14 whenever special resolution is done in a company. Whenever a company passes a special resolution, they have to file MGT 14 form. MGT 14 form basically gives all the details about the special resolution to the ROC. I told you every decision has to be will only become official when it is filed with ROC. Next is special resolution is required for maximum borrowing allowed. Let's read this. Should specify the maximum borrowing amount allowed, which means what? Shareholders may tell to the board that maximum you can borrow this much. Beyond that, you will require whose approval? Our approval. Consequences: if board exceeds the limits, then the transaction is invalid. Now, exception is lender acted in good faith, plus he did not know about the violation. People, did I teach you this? I taught you this, right? In the board of directors and KMP chapter. Same thing we taught you. Same thing I taught you. People, if you want, you can take a quick screenshot of this. You can take a quick screenshot of this. 5, 4, 3, 2, 1. Next, audit committee. Now we're going to understand about audit committee. Audit committee is applicable to whom? Listed company, public company, whose paid up share capital is more than 10 CR, turnover is more than 100 CR, and outstanding loans, borrowings, debentures, bonds is more than 50 CR. These companies will have to appoint an audit committee. Number two, composition of audit committee. At least 3 directors should be present, and an independent director should have the majority. Majority of the directors should understand the financial statements. Composition should be disclosed in the board report. How are the audit committees formed? who are forming audit committee, what are the qualifications, what are the expectations, what is the experience. Every single thing should be disclosed in the board report. Next, board for rejection for recommendation, which means what? If audit committee has recommended an auditor and board rejects the recommendation given by auditor, the reason why the board has rejected the recommendation has to be disclosed in the board report. Next, authority to investigate any matter. Audit committee has the authority to investigate any matter. And what is the role of auditor? To provide feedback on the internal controls plus audit scope. Number two, auditor cannot vote in the audit committee. Auditor cannot vote in the audit committee. Are we clear, people? Now, what are the responsibilities? Responsibilities, people: recommend the appointment and remuneration of auditors, number one. Number two, they review the auditor's performance and auditor's independence. Number three, examining financial statements and audit report. Number four, approve or modify RPT. Number five, scrutinize intercorporate loans and investment. Number six, valuation of company's assets if required. Number seven, evaluate internal controls plus risk management systems. And last, monitoring the end use of funds raised through IPOs. If the company has raised funds through IPO, now the directors are buying Ferrari, Lamborghini, which means what? In that case, audit committee is going to come and then tell them that you cannot do this, otherwise we are going to report in the board report. All right. Next is powers of the board. People, we have understood this. Yes, this is done. CSR is also done. But let's talk about constitution of CSR committee. 3 directors are required, with at least one should be independent director. For a private company with 2 directors, both must be committee. People, this is also done. For a foreign company, the authorized person and another nominee are the committee members. Exemption. This is important. This we did not study, people. This if a company does, one second. Let's say a company is forming a CSR committee because net profit is 5 CR or more. Let's say in the next 3 years, company suffered a loss. If company suffered a loss in the last 3 years, because of which that triggered for forming a CSR committee was triggered, then in that case, from next year onwards, company is not required to appoint a CSR committee until unless that triggered is again, the threshold is again triggered. Till that period, the company is not required to form a CSR committee. Understood, people? People, do you have any confusion in this? The functions of CSR committee is to monitor CSR implementation, recommending CSR policy and modification, recommending projects for board approval. People, till now, do you have any confusion in whatever I have taught you? Any confusion in whatever I have taught you till now? Who all are there? Give me a thumbs up. Give me a thumbs up. Who all are watching this video right now? Give me a quick thumbs up. There are 14 concurrent viewers over here. Yes. All right. Next is registers and record maintenance. These are registers that have to be maintained by the company. People, this question was asked in the last attempt. All clear? Perfect. People, this question was asked in the last attempt. What are the registers company has to maintain? Perfect. Atul, Devika, Tejasvi Bawal, Chandrasekhar, Gopal sir, thank you so much for staying with me so late. I am again apologizing for extending the session beyond 9 p.m. guys. My apologies to you. Give me 5 to 10 minutes, we'll complete off before 10 p.m. So what are the registers company has to maintain? Investment register, register of deposits, securities buyback, charges, members, debenture holders, beneficial owners, foreign register of members and debenture holders, annual return copies, minute books, postal ballot register, books of accounts, cost accounting records, register of contracts and interest of directors, register of directors, KMP, loans, investment, 17, 18, 19, sweat equity shares, inspection and storage of register, duplicate share certificate, register. Now, these are the register you have to maintain. Now, people, I would want you to learn at least 10 registers before the exam. I would want you to learn at least 10 registers. Over here, people, I will tell you, investment is very easy. Investment is very easy. Deposits is very, very easy. Charges is easy. Members is easy. Minutes, books is easy. These are all things we have studied, okay? Books of accounts is easy. Cost accounting records you will never forget. Register of directors and KMP. Loans, investment guarantees. Yes. 1, 2, 3, 4, 5, 6, 7, 8, 9. And foreign register of members. Yes. People, these things I expect you to learn. Sir, in CSR, provision need 2 conditions satisfy and any 1 condition not satisfy. It's CSR. Pooja Gupta, I do not understand. Pooja Gupta. 1 second. Pooja Gupta. Can I see your chats in mobile? Pooja Gupta. Sir, in CSR provision, any 2 conditions satisfied and 1. Pooja Gupta, are you asking me that out of the 3 conditions, only 2 conditions have not satisfied and 1 condition has been satisfied? Okay, 1 second. So Pooja Gupta is asking, Pooja Gupta is asking me that only net profit is triggered, remain 2 have not been triggered. Still, a company is supposed to follow. Company is supposed to form a CSR committee or not? Yes, Pooja. Yes. Any 1 condition, even the company triggers, it has to follow. Understood? This provision will become applicable. Okay. We are not going to wait for a company to cross a turnover of 1000 crores or net worth of 500 crores. Understood, Pooja? Any 1 provision, if it is triggered, then the company has to form a CSR committee. Yes, perfect, 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 perfect. Now, duties of directors, director duties and liabilities. When will the director be liable to an outsider? Over here, we're going to understand what are the duties of directors and to whom are they liable and when are they liable. Number 1, when are they liable to outsiders? When they act beyond the company's legal powers. When they act beyond company's legal powers. If the director acts beyond their granted authority. Can anyone tell me the difference between the 2? Company is into the business of mobile. Director enter into a contract with a clothing brand. Even the company is into the business of mobile. So that means what? On behalf of the company, director is entering into a contract with a clothing brand, which means company is going outside its memorandum of association. Company is going outside the powers. Director is going outside the powers of the company. Hence, he cannot do that. If the director acts beyond their granted authority, which means what, people? Director cannot sign on transactions alone that exceeds 1 CR. This director signs, which means what? He exceeded his authority. In that case, it is called as exceeding authority. Number 3, acting in personal capacity. Director is not representing the company, he is acting in his personal capacity, then he will only be liable, company will not be liable. Number 4, misleading prospectus, which means what? when a company is going for an IPO, director has portrayed wrong image of the company, saying that our profit is 100 CR in the last 5 to 6 years, whereas the profit is actually 5 CR. In that case, if you are misleading public by portraying wrong figures in the IPO prospectus, what is the meaning of prospectus? Offer document. A company going for an IPO, in the offer document, you are portraying false financials. In that case, director will be held responsible. If he does fraud, irregular share allotment means what? He has allotted shares to that shareholder who has not paid money. In that case, he will be held responsible to the outsider. Fraudulent trading, he will be held responsible. Liable to the outsiders. Company will not be liable in this case. Company or shareholders will not be liable in this case. Whatever it is, the liability lies on the director to the outsiders. Next, liability to the company. When will the director be liable to the company? When he is negligent, that causes financial loss to the company. Number 2, he has exceeded his authority. Number 3, illegal acts of fiduciary breach, like Vijay Mallya or Nirav Modi commit illegal acts of breach their fiduciary. What is the meaning of fiduciary? Means trust, a relationship of trust. In that case, directors will be liable to the company. Number 3, liability to shareholders. Breach of fiduciary duty, same, misuse their rights, cause losses to company or shareholders due to negligence. Even in this case, specific shareholders can also be harmed by the director, or all the shareholders can be harmed by the directors. In that case, the director will be liable to the shareholders. Now, liability for stat default or violation. You have not paid GST, you have not paid TDS. In that case, directors are responsible for ensuring compliance with stat provisions. Failure to comply will result in penalties, fines, and other legal consequences. So, we understood 4 liability: liability to outsiders, liability to company, liability to shareholders. Number 4, liability for stat defaults and violation. Now we're going to understand composition of board, and then we are done, people. Then we are done. All right. Composition of board. Question will be asked in the exam. Discuss the composition requirements for the board of directors under the Companies Act 2013 and SEBI regulations 2015. So, if for private company 2 directors, public company 3 directors, 1-person company 1 director, maximum number of directors is 15. We know this. Now, as per SEBI regulations, board of directors must have a mix of executive, non-executive director. We know this. For a listed company, minimum number of directors is how much, people? Can anyone tell me what is the minimum number of directors required for a listed company? Can anyone tell me the minimum number of directors required for a listed company? People, minimum number of directors required is 6 members. 6 directors are required in a listed company minimum. Female director in every listed company, at least 1 female director is required. For top 1000 listed companies, there should be 1 independent woman director. If it is not under 1000 listed companies, one woman director is required. If it is under top 1000 listed companies, 1 independent woman director is required. This we know this, people. If the chairperson is non-executive, 1/3 of board must be independent director. I also told you the logic behind this. If the CP is executive, at least half should be independent director. Easy. Now, let's understand the composition. Board of directors, minimum number of 6. Independent directors, as per regulation, we know this. Chairperson, we know this. Meeting frequency, we know this. For audit committee, minimum number of directors is 3. Number 3. Independent director should be 2/3. And chairperson should be mandatorily be independent director. Chairperson should be mandatorily be independent, so that audit committee performs completely in an unbiased manner. Nomination remuneration committee, minimum number of directors is 3. and more than 50%, at least 50% should be independent director, and chairperson should be an independent director in nomination remuneration committee. Stakeholder relationship, minimum members is 3. Independent directors, at least 1 should be independent director, and next is chairperson should be non-executive director. Now, how frequently are they supposed to meet? Audit committee should meet 4 times a year. Nomination NRC committee should meet at least once a year. Stakeholder committee should meet once a year. People, question will be asked in the exam for 7 marks. You have to learn this. I have also told you logic, so you will not find any difficulty in learning this. What do we say? Limits. Easy. Is everybody with me? Give me a quick thumbs up. Is everybody with me? Committee of the board. There are questions will be asked in the exam. Discuss the composition requirement for the board of directors under Companies Act 2013 and SEBI LODI regulations 2015. So now we're going to understand composition of board. Last topic and then we are done, people. Question will be asked in the exam. Explain the role and functions of various board committees like the audit committee, nomination remuneration committee, and stakeholders relationship committee. You have to tell them. Provision applicable. Pooja Gupta did not understand. Provision applicable. For which question was this answer? Okay. Committee, audit committee is responsible for reviewing financial statements, risk management policies, and internal audit reports. Easy. NRC committee responsible for managing the appointment and compensation of directors and KMP. Stakeholder is responsible for handling investor grievances and shareholder concerns. Last is risk management committee. Identifies and mitigates risk that could affect business operations. For 7 marks, people, you can just simply write this and just explain this using an example. That's it. We are done with the chapter of board of directors, minutes, and KMP. Board of meetings, KMP, and board of meetings, minutes, and registers, people. Sorry. Is everybody with me? Who all are with me right now? Just give me a quick thumbs up. Just give me a quick thumbs up so that we can move on to the MCQ part. Yes, Atul. People, these are the expected questions. I've given you expected questions. I've also given you answers to these expected questions. Okay. For every case, I've given you a question. So you have my notes. You simply have to read, understand, and learn the notes. You don't have to do anything, people. Everything I have given to you. I've given you 50 MCQs per, not chapter, but per sub chapter. I've given you 50 MCQs. Then I've also given you all the important topics along with the explanation in the crispiest way possible. Number 3, I've also given you expected questions that will be asked in the exam. What else do you need, people, to score an exemption? Everything I've given you in my marathon notes. Simply by learning the marathon notes, people, trust me, nobody can score you. Nobody can stop you from scoring exemption. This is my promise. I also taught you how to write answers in the best way possible. I also taught you how to tackle case study questions. Everything I've taught you, people, everything in this marathon I've taught you. Nobody can stop you from scoring exemption now. Okay, now let's move on to the MCQ part. Second question. Tell me the answer. Second question. If a director attends a meeting via video conference, will they be counted for quorum? Yes, people, quick. Now I will say people. Yes, second answer is B. Pooja Gupta is saying second answer is B. Yes, guys. Yes. Hi, Chris. Where are you from? Chris. Answer is B. Perfect, guys. Perfect. Amazing. Now, next question. Two-third or more directors are interested. The quorum is perfect. Veni, Atul, Chris, Devika, Pooja Gupta. Amazing, guys. Amazing. Chris, what is your full name? And where are you from, bro? Tell me properly. Were you watching this marathon from the beginning or just now you have joined the marathon? Guys, what is the answer of third? If two-third or more directors are interested, the quorum is ignored. All directors present, only non-interested directors, minimum two. Or number four, chairman plus one director. What is the quorum? Just now, I'm in 12th grade. Chris, what are you doing, bro? Then where are you from? Third answer is C. Yes, perfect, Madhili, perfect. Next, in case of vacancies, the remaining directors can only act can act only to pass routine businesses, borrow money, appoint new directors, or call a general meeting or sell assets. Atul PS, Devika, Pooja Gupta, Maithili, Gopal sir, answer the question. Where is Tejasvi Pawar? Devika 4C, Atul PS 4C. Yes, people. Perfect. For Section 8 company, quorum is 2 or 25% of total strength, whichever is less, one third of total strength, 5 directors, or no quorum required. What is the answer? After this, only one question and then we'll be done, okay? Maithili 4C. Amazing, Maithili, amazing. Perfect, guys, perfect. Atul, Devika, Gopal sir, great, guys, great, perfect. You all are right. 5 answer D. No quorum required. For Section 8 company, no quorum required. Answer is A, Atul. A. 2 or 25% of total strength, whichever is less. People, I think over here the option is wrong. It is 8. Minimum of 8 or 25% of total strength, whichever is less. Yes. Last question, then we will be done. Okay. Last question. Yes. One third directors demand discussion. The resolution must be passed automatically, dropped, taken to a physical board meeting, and last is deferred for 1 year. Yes, guys, what is the answer? What is the answer for 18th question? Devika is saying answer is C. Perfect, Devika. Amazing. So we will end here, people. We will end here. 18 answer is C. Atul PS. Perfect. We will end over here, guys. Tomorrow we're going to complete off with the Companies Act 2013. Remaining small chapters we are going to complete it thoroughly. Those who did not get notes, just tell me who did not get the notes. I'll ask my team to get back to you. All right, people, please take the notes. Okay, do anything but take the notes. It is very important. All the important topics have been covered in the notes. All the expected questions have been answered in that notes. All the MCQs have been given in that note. So there is no reason for you not getting an exemption if you do not study the notes. Okay, study the notes very carefully. Everything is there in the notes. All right, perfect, guys. Perfect. Thank you so much. Thank you so much for watching this marathon for 4 years. Thank you, Devika. Thank you so much. Thank you so much, guys. I would want you to drop a like, give us a give us a comment, or share this video to as many people as possible so that everyone will get benefit from this marathon lecture, people. Okay, thank you so much, guys. Thank you so much for watching for so long, for staying so long. You guys are the motivation for me to teach for so long. Thank you so much, sir. Thank you so much, Chandrasekhar sir. Thank you so much. I will see you guys tomorrow. Please come tomorrow also. All right. Yes. Veni. Yes. Siddesh. All right, guys. All right. I will see you tomorrow. Bye bye. Good night. Welcome, Atul. Welcome, Veni. Welcome, Maithili. Welcome, Gopal sir.